continue the case today because I got this captain operated yesterday. Then so item number 17, my lord, maybe taken either 14 or 17. Because I was engaged yesterday. So
17.
17.
Okay.
Obligement.
Item 14.
No, item 17. 17 on 17.
Okay.
Obligement. Item 17.
May it please lordship, I beg to mention for listing of a criminal petition, my lord, where I'm apprehending an arrest in a cow smuggling case, my lord. That can it be on Monday, my lord? On 11th, the case is listed before the lower court, my lord.
When did you file?
My lord,
When did you file?
I filed it, my lord, 37/2024. It was last listed on 9th, my lord. Deeply obliged.
May please, my lord. My lord, I beg to mention item number 36, my lord. My lord, I may be allowed to withdraw this petition, my lord.
Just wait for a few minutes. Mr. Mazumdar, we pass the order as soon as the mentioning is over.
May it please, Your Lordship. I beg to mention item number 43, my lord. May I pray for taking up this matter at 2, my lord? The appellant, this is a criminal appeal, my lord, along with an IA, my lord, for suspension of sentence and bail, my lord.
Okay.
Oblige, Your Lordship.
May it please your lordship. Lordship, I beg to mention a bail application under special act. Lordship, because the matter has ought to be mentioned before court number 18. However, court number 18 was available today. And on inquiry, my lord registry has informed us that this being the senior most bench, mention be made here. Lordship, this is a regular bail application. Lordship, for 9th, because connected matters are fixed on that day, my lord, on 9th.
When did you file?
Lordship, I filed day before yesterday, my lord.
You have the number?
My lord, I have the filing number, my lord,
Okay.
that I'll provide, my lord.
Yes,
Deeply obliged, my
Lordship,
lord.
item number 61, supplementary hearing, Lordship. Lordship, I have seen the list of the so many matters are there. So Lordship may take up on next Tuesday, Lordship, on 10. Lordship, Tuesday
Not on
hearing.
10. 12.
12, Lordship. Obliged.
May I please, Your Lordship. Your Lordship, I beg to mention item number 18, 21, and 39, Your Lordship. Your Lordship, in these three matters, Your Lordship, Mr. M. Ahmed is supposed to appear, but he is unable to appear because of his health issues, Your Lordship.
18.
Item 18, 21, and 39, Your Lordship.
Mr. M. Ahmed, counsel for application. It is stated as a verbal editor. Is in this. It's expired to me for yes.
Hello. Yeah, please, Your Lordship. My lord, with all respect, my lord, I beg to mention item number 23, my lord, on behalf of Asmunir, my lord. My lord, may I seek adjournment for the day, my lord? Let the matter be fixed on Tuesday next, my lord.
After
Item number 23.
yes.
May I please, Your Lordship? I recommend item number 13, Lordship, with the consent of other side.
After a week, Mr. Fook.
Lordship, item number 13. 2 weeks time may be given, Your Honor. Lordship, we have been recently engaged in this.
After 2 weeks. Needed to be fixed by the judge.
Yeah, please, Your Lordship. Your Lordship, I beg to mention for listing.
Declare of the petition.
Lordship, I beg to mention for listing of criminal petition.
When did you file?
So we have the matter is of 2022, and we have recently appeared for entire appearance by filing the particular number. So due to this, the matter before the learned trial court has been
11th. 11th.
May I please, Your Lordship? Lordship, in item number 22. Item number 22 is fixed for Lordship bail hearing, Lordship. And though TCR was called for, but it is the second occasion TCR is not available, Lordship. Therefore, the matter may kindly be adjourned for a week and kindly fix a date, Lordship.
18th. On a date to be fixed on the meanwhile, reminder to 11 records that was called for by the. Yes.
May I please?
Much obliged.
I beg to mention a listing of the criminal appeal. Lordship, last were listed in 18/7/2023.
Okay. On 13th.
May please, Your Lordship. I beg to mention in IA, Your Lordship, for suspension of sentence, Your Lordship. It was, Lordship, the petitioner was in jail more than 7 months, Your Lordship. Next week, need it, Your Lordship. And with 13th, Your Lordship.
Yes, on 13.
Yes, it's a lordship, I beg to mention for listening criminal petition 2023. Last posting 19/7/2024.
16th.
Item number 30, Lordship. So the idea was called for, I didn't not receive, Lordship. Only item number
30, someone already mentioned.
30, Lordship.
Already mentioned.
I am the advice counsel, no other counsel. 30, 30, Lordship. In bail hearing crown, Lordship.
Someone mentioned them for M. Das or M. Ahmed. Someone mentioned for you, I don't know. Anyway,
Someone
after
NPM,
2 weeks only
Lordship.
date to be fixed. So 2 weeks is enough. Okay.
Right, please, your lordship. Lordship, I beg to mention item number 7, lordship. I'll pass over this matter only for the day, lordship. Next week, any date, matter.
3 weeks only date to be fixed with the next day on the third.
I beg to listing the matter for orders, Lordship. Matter related to maintenance, Lordship.
12th.
12. May 3, I beg to mention item number 34, my lord. For the day, my lord, kindly. My lord, case diary was called for, my lord.
There is not here.
So it's case diary receipt. Case diary receipt.
You want adjournment?
Yes. So there is a voluminous case.
Go through it.
Yes, my lord.
After 10 days on the date to be fixed with the inst.
I beg to
Yes.
mention item number 27, Lordship. Mr. PP Medi is out of station. Lordship may kindly adjourn this matter for today and fix it on next week.
Council for the petition. After 2 weeks of the date to be fixed with the inst. Yes.
May please, also, I feel for listing a bail application, it was listed on 2/9, my lordship. Already charge sheet has been submitted, but on that day it will become leftover. Just for any date, my lordship.
11th.
Lordship, I beg to mention for listing withdrawal, Lordship.
Listing for orders
Withdrawal.
tomorrow. I won't know.
Relax,
Kali I will.
May I please, Lordship, I wish to mention for upgradation in item number 45. So last occasion, Honorable asked to made a mention, Lordship. So matter is regarding suspension of sentence, Lordship.
We'll take up before rising. Around 3 o'clock.
Your lordship, I would like to make item number 50 is for anticipatory bail. The engaged senior counsel is not able to be present in the court today due to personal problems.
After
Kindly fixed on 10th year on.
3 weeks on a date to be fixed with it.
Which item?
Yes.
Which item?
Your Lordship, I beg to mention item number 29. The matter may be adjourned for the day because the Mr. T.L. Oscar is out of the station, Your Lordship. And kindly list the matter after 1.
Okay.
Much obliged.
Item number 35, maybe possible for the day, madam.
Okay, Mr.
Problem.
3 weeks on a date. Good. Mr. Mozumdar, what was that matter?
Item number 36, my lord. For withdrawal, my lord.
You are not praying 36. You are not pressing 36.
Yes, please.
35 and 36 together.
Mr. P.K. Mozumdar, counsel appearing for the petition. And I'm as the non-law resident for prosecutor appearing for the state. Opposite party number 1. Petitioner was arrested on 30/05/2025 in connection with special case number 38 within bracket M public 2024. Bongaigaon, arising out of Manipur and special case number 168 of 2023 under section 120B 366A 373 IPC related section 6 of the POCSO. Petition number on 2707 2024 clarification. Seeking bail in state succession. Special case number 5. Noted. However, instructed, Mr. Madhumdar, learned counsel, is not pressing this petition. And counsel for the so is the counsel for the particular number one. No, particular petitions and this was.
Pakala
35 to separate.
May I clear the lordship? I got to mention for listing lordship. Lordship, I have filed anticipatory bill on 2/9/2024 lordship. Till that, not listed lordship, not even listed summary lordship.
9.
And list.
May please, your lordship. This is a regular bail application, my lord. Today is 64 days, or less. CD may be called for my lord, as the case was.
Sections from BNS are mentioned here to see.
Did they call case diary?
Lordship, yes, in fact, there is a common object also. This is from Bhawanipur.
Gozali,
Mojali.
12 or 13.
এটা কি মারে আজকে কি মাস যাবে সেপ্টেম্বর এর ফলে পালো এটা মোশন 16th of September or earlier to that.
Petitioner was.
City was already called upon, right? Huh? No, no.
In connection with particular case number 138.
Hmm?
And I think now,
No, এটা কি লিখে দিয়েছে আমার?
Bhawanipur, entry number 31. This is 023.
I should have checked up the file. In fact, in my file, it is written that CD was already called for on 29/8.
Maybe in connection with other case, because there are,
But Manohar Ali, it is written here. 29/8/24. The matter came up.
just a minute.
It's okay. বর্গিটা আছে এটা বড় মনে হয় ইউ আর রিপেয়ারিং ফর হেরি তাহলে এবার আনিস না রেসপন্ডে না ওই কুলদীপ Informant side have also appeared, so perhaps it has come once.
It was listed 29.
29 of
Listed, I also did, but the CD was called for, but subsequently
oh dear.
ordered from the record.
My learned friend is saying that it has come up on that day and that CD was also called, but it was not reflected in the order sheet. কোথায় আছে?
More than 7 years to them. More than 7 years. No, you're happy with it.
এটা murder আছে তো এতিয়া এই BNS ৰ section টো নাজানো নহয় Arms Act আছে না নতুন অখনৰ section টো একো নাজানো নহয়
So this is the same one.
Lordship
There is no mention for calling of the case diary earlier. The same thing. It was earlier listed on
29.
29th,
29/8
but case diary hasn't been called for.
আচ্ছা
Yes, when
When any date September 16th or even earlier to that
12 or 13 maybe.
today is 5th.
From Bodali, my lord, under
16th.
16th Lordship
all. Lordship case is after the case is 8 lordship.
POCSO is there
Yes, lord. Lordship, here punishment is lordship 3 years in respect to sections 12 lordship of POCSO, and sections 8 is in respect to section 8 lordship punishment
Miss
is
Jahan, notice has to go to the informant in this matter.
Lordship will issue notice to the
Petitioner was arrested on 20/08/2024. In connection with Gulabganj PS case number 189/2024. Reference GR case number 933/2024. Under section 126, in bracket 2 of 157, in bracket 2 public 75, 77. Of BNS.
One
Eight,
effect,
section
another.
8 of 5 of POC 2003. Earlier his bail application. 21/02/2024 was rejected for the additional session that comes special as structure. And this bail application. Yes, records
Lordship.
when
Lordship is calling for the case diary.
Yes.
23rd,
23rd.
23rd, yes. In fact, this notice to the informant is taking long. Mr. Makhan Fukan is here, PPA. He can apprise your Lordship. The notice to
Yes,
the
Mr.
informant.
Fukan. What steps are you taking? Because what we have seen, the concerned police stations are not reporting back the matter.
my lord.
Either they don't get the papers because we send it by post. Few letters I get, they have not received. Then I again send it through WhatsApp.
Lordship,
It's really,
both registered post as well as lordship.
no, this is true registry.
This is notification has come.
In fact, the email should be there in each and every police station.
It is very important.
No, it is there, but my lord, I don't know why they have not compared it. Email is also there, my lord.
You have the email addresses of all the police stations?
That has not been provided, but some of the few SP office emails is there along. But the sub police stations we don't have, but the SPs we have, my lord. Every district SP's emails it has.
Do you have any officer on special duty regarding the collection of these orders or whatever?
One nodal officer is there, man.
He
in
is
our
to-
office.
He is to visit every day.
My lord,
He is to visit every day
where, my lord?
in your office.
My lord, only one nodal officer appointed by the CID office. He every day is present in our office.
That is only with regard to CID matters.
My lord, though my lord, sometimes what happen, if we cannot get the, my lord, the information from the other person, we contact them and they will help us, my lord. And one nodal officer who is appointed by our government, he can communicate, my lord, all the concerned police stations, my lord. He is not from police, my lord, he is our employee, my lord.
Steps on the informant. Opposite party number 2, respond number 2. Could you register this code in terms of the notification numbers by tomorrow? Serving a copy of that for a review. Okay? Take steps on the respond number 2. by
Highly
tomorrow.
obliged, Lordship.
My lord, page number 7 is the FIR, my lord. Under section 21C and 29 of the NDPS Act. My lord, CD may be called for, my lord, along with FSL, my lord. Suspected heroine, my lord, is seen. Page number 11 is there.
From Silsar, yes, when 23rd will do.
23rd of September will be too long, I think. 16th of September,
You'll get it.
Lordship.
Good.
1 week is there in between.
Along with FSL.
FSL, I hope police have got it. If police has received it, they'll send it.
Take it.
60.
Silsar case number 573 of the 21, McKinsey of 29. Arrested on 27/06.
Obliged.
Along with the FSL. Subject to its availability.
May I please, your lordship? My lord, the petitioner is behind bars since last 14 months in connection with this case. So, scan copy of the case.
Arrested on 25/06/2000.
Lordship. But the arrest with the
What is charge? May I please?
assessor, original.
16.
No, the case, Harry will come.
Pending where?
My lord,
Offense report filed.
charge sheet file, my lord, 2 witnesses examined out of 9 witnesses.
Scan copy of the records.
What pending was a
Arrested
sub-divisional judicial magistrate.
on 25/06.
Oh, special judgment.
NTPS case number 42/2023, and I think also from your PS case number 3/1/2023.
Registry यहाँ पे हमको registry अंदर.
See, public 29 of the NTPS Act. From the Court of Learned Special Judge. Is it in Rongia?
Yes, Rongia special judge.
Come with Rongia. Scan legible copy. Nineteenth.
My lord,
Registry will bring.
Registry will be.
Now, Chief.
19 is fixed, my lord. 19 is fixed. Obliged.
Clear, please. Intermediate lordship. The petitioner is behind the bar from lordship 5822 lordship. Okay, case back the call for lordship, yeah,
Lordship.
32 days behind the bar.
He present.
Intermediate. Ganja.
When he
Ganja.
was arrested.
Arrested on 5824 lordship.
Arrested on 52024, action with Manipur case number 108/2024. Section 20 in the small b of the 29 of the NDPS Act, section 4 of the Section 7. Hung for your issue. Yes,
Lordship. This is Bongaigaon. 17th September.
Obliged.
P76 and POCSO.
Yeah.
26. Arrest. Manipur PS case number 79 of 2023. They will check and see 6 of the case. Notice to the party number 2. To be raised to this. 23rd, same.
Lordship. And notice.
Obliged.
May it please your lordship, the anticipatory bail prayer, my lord, limited prayer, my lord. But in this case, this is a charge sheet case where I've been shown as an absconder. And straight away, my lord, NBW was issued against me. And for the last 4 years, my lord, NBW has been issued against me. One of the reasons why I was unaware of the fact that NBW was issued was because the case has been registered and charge sheeted in a different name. My name is Imdadul Haq. Matter of allegations are directed against me, but in the charge sheet it has been given as Anzar Ali. My lord, we find the relevant part of the charge sheet at page 17.
Anzar Ali.
Anzar Ali. My name is Imdadul Haq.
Alias Anzar Ali.
Now we have given as alias because the allegations are attributed towards me, but they have charge sheeted me as Anzar Ali. And my lord will kindly see page 24. Cognizance has been taken and straight away NBW has been issued. So I am otherwise willing to appear, my lord, and contest the case. Only because of the pendency of the NBWA, there is an apprehension. So if some limited protection may be extended, my lord, I'll appear on the next date.
In that case, he could have moved a 482
That
application.
would have been.
Yes,
file it, that
instead
will-
of AB.
What is the
If I-
next date?
My lord,
What is the next date?
next date, my lord, is on
Still there is
23/9.
time. Still there is time.
23/9.
Withdraw it and file a 482 application.
And the only thing is that because NBWA is pending, that is why we are seeking anticipatory bail only in that
That is
regard.
why
There's an
we said now,
apprehension is
you
there.
file appropriate application, will pass the offer. Better withdraw it and file the appropriate application, we'll consider. That will be better.
To stay you go and appear and then.
In this matter, we are not going to consider, we will reject it. Up to you.
My lord will give us some time, then we'll try to satisfy your lordship that AB in this scenario is also maintainable, my lord, in terms of.
AB will also be maintainable, but here there are two kind of prayers, it seems.
We are not seeking any quashment of the NBWA, my lord. We are seeking anticipatory bail in terms of the severe judgment, my lord.
Considering the charge sheet will not allow you for the anticipatory bail, as you are now aware of the fact. Anyway, up to you. On the priority council for the petition, please start.
Please after a week.
I'm deeply obliged, sir.
This is that asset and liability case, Lordship. In fact, Lordship, I have checked in the other journals as well. I get the same one. It is passed under 141. Yes, sir.
So this matter will be kindly taken up after some time, my lord. MS M Bhattacharya will appear for the respondent, and now at present she is leaks.
Will be appearing.
M Bhattacharya.
M. Bhattacharya. She is also in one of the matters.
Consider her. So,
Lordship. Lordship can see the finding part. It is 141. But in 141 also, Article 141 also, Supreme Court can make the courts follow their dictum.
yes.
In fact, still Lordship will see this Rajneesh versus Neha. Yeah, net
You want the citation?
Lordship. This is Rajneesh. Ahilaba. This is 2021 2 SSA 324.
The last part.
Before the guidelines. Lordship will see paragraph 1, final directions. Lordship will see paragraph 127, page number 383.
Yes.
In view of the following discussions as contained in part B 1 to 5 of this judgment, we deem it appropriate to pass the following direction in exercise of powers of 142.
Yes.
But these are enforceable. And these are the
Conditions.
guidelines where it is said that party has to file their asset and liability in the table form.
As specified in that judgment.
Yes.
Yes.
Lordship.
This way, the 4% discretion is.
Uh-huh.
4% can exercise his
No,
discretion.
as far as asset and liability.
Exactly.
And then they will,
And the discretion is there.
the quantum they will decide, but then asset and liability they have to file. Oh. No, 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 I was not. This is a problem. এটা নেটেই না থাকে। Internet is not working here, Lordship. Otherwise, after that, Supreme Court has directed, when courts were not following the guidelines, Supreme Court has directed for recirculation of the judgment among all the judges of all over the country. That is, I think, Aditi versus Mithi. Aditi Elias. 142.
Interim, interim.
Payment of the interim maintenance, but in view of the foregoing discussions, in part B.
Quantum of maintenance is there, discretion of the court is there.
Assets and liabilities have to be taken because they can interim maintenance to consider for it. At the time, there is no evidence by either party.
Yes.
So one of the reasons why this was given, that for the court to have something.
Otherwise, the other part is 141.
Other part is one.
The requirement of filing, sorry, asset and liability, it to put us. Asla no?
Yeah, they do. Asset and liabilities. Assets and liabilities.
It about interim. May not, and
I'll say interim maintenance. Assets and liabilities. That comes in the part dealing with interim maintenance. Not to be expected.
कोई जैसा तुम्हें verify किया ना?
Hmm.
69.
There are 61 of us. Payment of interim maintenance. Page number 367.
Wi-Fi की यार वो
No, mobile.
Oh, अच्छा. 60, 127.
Directions and overlap. Put the पैसा कल आपने?
Paragraph 62.
Two, अच्छा.
Part
Payment of interim. और वो main maintenance का ना asset liability नहीं है?
Yeah, if you take the patent fee in it, last price, that is the time of deciding interim maintenance, and the state doesn't have any evidence to decide what is the intention of either party. If the party is very happy to continue, please not the quantum needs to be determined. So we need to focus for the purpose. There is an evidence. One can always prove the
Income and all. Asset and liability only in respect of interim maintenance.
But subsequently, they did not clarify to me what. But if we didn't contact it,
In these are cases on interim maintenance. Oh, no, new point has cropped up. What my learned friend is saying is asset and liability is required only for interim maintenance. Main maintenance, they will find out what the income is of all the parties. This is what, of course, I did not.
If my lord has paragraph 129 of the judgment, where they have given the effective finding, this comes under the heading of payment of interim maintenance. One of the reasons why this was given was when the courts are ordinarily deciding the quantum of interim maintenance, the parties only have their pleadings before the court. There is no evidence as to the income of either party.
So that is why one of the reasons why the Honorable Supreme Court directed that both parties should file their affidavits of assets and liabilities was so that the courts had some material before the court to decide the quantum of interim maintenance is payable. Subsequently, the Supreme Court from para 62 onwards has gone on length and discussed this issue. And the affidavit of assets and liabilities for the first time comes up in these paragraphs, madam, from para 62 onwards. But the main reason this comes because at the time of final relief, both parties also have the option of producing evidence. Evidence it is useful, right? So evidence it is getting proved. Even without this,
And in paragraph 130, lordship, discretion is there to the adjudicating court lordship to assess the quantum lordship.
Part 3 decides to keep the criteria for determining quantum of maintenance.
Okay.
Here, interim
is also?
Yeah, that was interim. Part 3 is not.
Part three কথা কৈছে তো, এই যে B and 3, while determining the quantum of maintenance, this will be.
আমি মানে status quo
What my Dana father said, asset and liability is required only in interim. It is so. Final discussion, payment of interim maintenance.
Criteria for
But credit time up into 3 to logo, part 3 and.
এইটো কথা পিছত আহিব আমাক লাগে asset and liability. It is 121. Affidavit of disclosure of asset and liability and extra the parties in all maintenance proceeding into. But the heading is payment of interim maintenance.
See, it's not only for that particular three. If you read paragraph. Read the paragraph 125, the heading just before.
125, the order of decree, the order or decree of
The
maintenance.
heading is just before the heading.
Discussion and directions on enforcement of orders of maintenance. So this will include all.
Everything. Now read para 125.
The order or decree of maintenance may be enforced like a decree of civil court through the provisions which are available for enforcing a money decree, including civil detention, attachment of property, etc., as provided by various provision of CPC, more particularly so-and-so read with order 21. Striking of the defense, the respondent is an order. Striking of the defense of the respondent is an order which ought to be passed in the last resort. And even 129, it includes, of course, the heading is payment of interim maintenance.
No, go ahead, then initiative, then
Yes.
next part is final direction.
Final directions. In view of the foregoing discussions as contained in part B, 1 to 5 of this judgment, we deem it appropriate to pass the following directions in exercise of our powers under 142 of the Constitution of India. Issue of overlapping jurisdiction, this was dealt with in the entire judgment. To overcome the issue of overlapping jurisdiction and to avoid conflicting orders being passed in different proceedings, it has become necessary to issue directions in this regard. so that there is uniformity in the practice followed by family court, district court, magistrate court throughout the country, we direct that where successive claims for maintenance are made by a party under different statutes, the court would consider an adjustment or set-off of the amount awarded in previous proceedings while determining whether any further amount is to be awarded in the subsequent proceeding, like in domestic violence and all of it. It is made mandatory for the applicant to disclose the previous proceeding and the orders passed therein in the subsequent proceeding. 3, if the order passed in previous proceeding requires any modification or variation, it would be required to be done in the same proceeding. Thereafter, Lordship will see B, payment of interim maintenance. Paragraph 129, the affidavit of disclosure of assets and liabilities annexed as enclosure 1, 2, and 3 of this judgment, as may be applicable, shall be filed by both the parties in all maintenance proceedings. So in all maintenance proceedings, irrespective of whether it's interim, prayer is for interim or main, including pending proceedings before the family court, district court, magistrate court is concerned, as the case may be throughout the country. Then for determining the quantum, they will use that. For determining the quantum of maintenance payable to the applicant, the court shall take into account the criteria enumerated in Part B, 3 of the judgment. The aforesaid factors are, however, not exhaustive, and the court concerned may exercise its discretion to consider any factors which may be necessary or of relevance in the facts and circumstances of the case. So, my learned friend is saying that it is required only in cases of interim.
It will be for all.
Huh? Yes, he will say.
So, my lord, what I'm trying to submit is that as far as the issuance, or as far as the question of determining the interim maintenance is concerned, as per Rajneesh versus Neha, both parties they mandatorily have to file the affidavit of assets and liabilities. But regarding determining the quantum of maintenance, the final quantum, my lord, the Rajneesh Neha says that it has to be determined in terms of the observations made in Part 3. Now, Part 3, my lord, as far as I've gone through Part 3, my lord, in Part 3, the affidavit of assets and liabilities has not been made a criteria for determining the quantum. Because at the time of final adjudication, my lord, both parties will be adducing their evidence and they will also be getting the opportunity of proving their respective income, their assets and liabilities. Whereas at the time of determining the interim maintenance, my lord, there is no, the parties do not have that option. So the only thing which they have to do is that they have to mandatorily file their affidavit of assets and liabilities. Now, that part is mandatory, my lord, that they have to file. But if it has not been filed, whether, my lord, your lordship will examine whether that vitiates the quantum of the final maintenance, my lord. In my respectful submission, my lord, the quantum of the final maintenance, which has been determined after evidence of both parties has been adduced, does not get vitiated even if this asset and liabilities has not been filed. Primarily for the reason that it is intended to assist the court to determine the quantum of the interim maintenance.
And this is also there, no? This is not only.
Has its discretion to exercise its own procedure.
Going through the process of interim maintenance. Can the final maintenance is right? Interim maintenance.
The subsequent case where the Honorable Supreme Court has ordered for recirculation of the judgment, that may make things clear. Whether that is a case of interim or that is Aditi. Aditi alias Mithi. Net না চলে মানে এটা মানে হ্যাঁ নকৰে আদিতিটো মই সেভ কৰি থলো এটা মই নোপোৱা আছো নহয় Aditi multiple books cannot be connected no অশান্তি পাইছো Supreme Today ko uliyaw ba no Supreme Today to আহিছে জানো
This is the format. এই ফরম্যাটের লোকে ইন্টারনেট কথা কি হবে তো ফাইনাল হবে
দেখো এইটো বা কি হয় Montana High Court has has reduced the maintenance. হেৰি নহয় চাগে interim. নহয় ইয়াতে recirculate কৰিব দিছে।
Maintenance related to that.
There is no
One is
litigation
the
should be-
interim
নহয়
maintenance.
ইয়াতে recirculate কৰিব দিছে।
Yeah.
From the okay, they have reduced it, no? এইটো overlapping.
This is the format applicable for.
Overlapping to
Final
there,
debt.
permanent alimony.
Maintenance or beleg maintenance.
এইটো overlapping of কথা কৈছে no?
Decided on the basis of its
It was noticed that detailed guidelines were issued.
in terms of maintenance, we decided on the basis of pleadings of the parties and on the basis of some amount of guesswork. It is offensive that the parties submit scanty material and no disclosure. Tendency of the wife to examine. Keeping that in view, the streamlined run to maintenance.
It one Rajneesh
Rajneesh
again.
versus Nihal.
Guidelines were given. The judgment was delivered on when affidavit, including pending proceeding, in all maintenance, in all maintenance, है ना? তাৰপিছত এইকেইটা এইটো ৰাজনেশ নেহাৰ Beg party may seek permission to serve interrogatories. No, a permanent alimony. Recirculate কৰিব দিছে এইটো ৰাজনেশ Aditi 14. Nothing is evident from কিবা paragraph হয় নহয়? It starts with what? Nothing. Nothing is evident. Starts with what words? মনোপত্র একে হবো। Nothing is evident from the record or even pointed out by learned counsel at the time. By further informs of judgment of which was directly communicated to all the high courts for further circulation to all the human. The case in hand is not in isolation even after pronouncement of it coming across a decision making maintenance, fixing maintenance, either interim or final, without there being any affidavit or record filed by parties. The subsequent decision, Lordship will see paragraph 14, Aditi.
Just,
Lordship.
do you have the citation?
This is,
To 2021 to SCC Lordship 324.
No, that is the Rajneesh.
this is Rajneesh. Aditi is 23. This is SCC, it's not in my,
It's not.
I'm seeing from Supreme today. This is Aditi Elias Mithi.
Mail to logic.
In most of the cases, Supreme today doesn't give SCC citations. ADITI, Aditi, alias MITHI, Mithi. এটা নেটে কাম নকৰে This 23 4 crimes. Crimes, I have the citation.
Mail of confirmation. Okay, no?
Rationally behaves to it.
Eight.
The why?
Hmm.
Required to be given.
Quantum of monthly maintenance force must follow FX code guidelines. Only this thing is stated.
In Aditi versus Mithi, what are the facts of the case?
Oh, yes. In fact, their amount was lessened by it was reduced by the High Court, the maintenance amount, not interim.
What is the observation of the Honorable?
Not evident.
Nothing is evident.
Lordship will go to paragraph 14. Observation.
Look, the para starts like nothing is evident. Para 15 of it.
Oh. High Court had reduced the amount on the ground that respondent was doing some private work and he is financially distressed. From 20,000, it was reduced.
20,000, you can 7,000.
This is in the apex court.
Then matter went to apex court. High Court reduced the amount. Then paragraph 8, it is held that normally what happens, the women's side reduces her income and shows exaggerated needs. These are and so Rajneesh Neha was passed. Then the entire format is given.
Either interim or final.
And then Lordship will go to paragraph 14.
This case, Lordship, sent back again to the High Court for reconsideration, Lordship. This Aditi alias Neha, Lordship. And then there was an order for recirculating, Lordship, the guidelines given in Rajneesh case, Lordship.
Why I'm showing paragraph 14 is সেইবোৰ তোমালোকে কৰা মই অকল ল পইণ্টে জানো হেৰি দিছা নি হেৰি দিছা হাৰ্ড কপি দিছা
You are relying on paragraph 14.
Paragraph 14 only to show that this not only applies to interim but also final. Nothing is evident from the record or even pointed out by the learned counsel. Lordship got it? Counsel for the appellant at the time of hearing that affidavits were filed by both the parties in terms of the judgment of Rajneesh, which was directed to be communicated to all the high courts for further circulation to all the judicial officers for awareness and implementation. The case in hand is not in isolation. Even after pronouncement of the aforesaid judgment, this court is still coming across number of cases decided by the courts below, fixing maintenance either interim or final. Interim or final without there being any affidavit on record filed by the parties. Apparently, the officers concerned have failed to take notice of the guidelines issued by this court for expeditious disposal of cases involving grant of maintenance. Comprehensive guidelines were issued pertaining to overlapping jurisdiction amongst courts when concurrent remedies of grant of maintenance are available under Special Marriage 125, Domestic Violence, Hindu Marriage, Adoption Act, and criteria for determining quantum of maintenance, date from which the maintenance is to be awarded, enforcement of orders of maintenance, including fixing payment of interim maintenance. As a result, litigation, which should close at the trial level, is taken up by this court and the parties are forced to litigate. So here, in fact, all the stages are included. In our opinion, the same to be set aside. And Lordship will see yes, and it was remitted to the High Court for consideration afresh. Ordered accordingly, as the respondent remain unrepresented, High Court may issue notice. Thereafter, Lordship will see 16 paragraph. Considering the facts of the case in hand and other similar cases coming across before this court, not adhering to the guidelines in Rajneesh, we deem it appropriate to direct the Secretary General of this court to recirculate the aforesaid judgment not only to all the judicial officers through the high courts concerned, but also to the National Judicial Academy and the state judicial academies to be taken note of during the training programs as well, ordered accordingly. So this makes clear that even in interim stage and even in the final stage, these
Not only
affidavits.
for the purpose of interim maintenance.
Yes.
But also it has to be considered.
Huh.
But here also, if you see the earlier judgment,
The word uses in all maintenance proceedings.
All men,
In all maintenance, although the heading is interim.
they have made it part by part because of their overlapping provisions and other provisions.
Hmm.
And that is why, in fact, even for final consideration, one
Mm.
part is no doubt the submission of all those brochures, 1, 2, 3 will be there. That is for the interim. But along with that, part 3B has to be considered for final
Yeah,
assessment of giving the comment.
quantum of,
That starts with paragraph 77 or something like that.
part B,
Part B.
forever. And these direction Lordship has sit under 142.
No.
Hmm?
And the Honorable Apex Court has verified that 142
Hmm.
will be applicable
Hmm.
till an appropriate rules or amendments are made in the rules of the particular
Yes.
act. So till then it is binding on all.
Binding on all. So in fact, many high courts have remanded the matter to the lower courts.
Here also, what in the case of whatever the interim maintenance has been given, we will not touch it with that.
Lordship.
We'll send down the matters for fresh
Yes,
consideration
Lordship.
on the basis of those brochures.
Yes,
As well as the
Lordship.
provisions. If it is a final amount, then it has to be on the basis of those materials
Yes.
to be furnished by both the parties. And paragraph 77 onwards has been paragraph 129 of the Rajneesh.
Lordship.
Followed
Yes.
by this additive versus material.
Lordship.
That's all.
But one humble prayer, Lordship, the maintenance be paid
no,
regularly,
that
Lordship,
has to
because
be-
in my case, it has been stopped only thrice, it
Here,
has been paid, Lordship.
so that is why we will send down the matters. Till then, the interim maintenance has to be paid.
Yes, Lordship.
And two high court decision I had taken out where the matter is remanded. If your Lordship wants, otherwise not required.
Yes, if you.
This is Nayan versus Pranita and Sunita Chishti. I'll give, my net is not working here,
No, it is not working here too.
Yes, Lordship.
but, Nayan versus, it will be Nayan versus Pranita, Lordship, I got it. This is, Bombay High Court. This is Bombay High Court. I'll mail it to my the learned court master. I'll mail it to him. This is 21 Supreme. Oh, Mama, mail koriye na. This is 21 Supreme Bombay 583. 2021 Supreme Bombay 583. This is Pranita, Nayan versus Pranita. And one more, Sunita Christie. Sunita. Sunita Christie. No, not Sunita Christie. But Nayan versus so and so will do, Lordship.
It's from Mumbai.
Nayan is from Bombay High Court.
There they have affirmed that this is applicable in both interim and the final maintenance, Lordship.
That is in Aditi alias Preeti.
Yes, Lordship.
Nayan also the same thing.
In Aditi and Mithi, Lordship, in para 12, another observation has been made, Lordship, regarding even after the divorce, Lordship, the husband cannot absolve the about the right of the child, Lordship. They have to maintain till the child gets majority, Lordship. This is their Lordship.
But that is a case with regard to a son.
Yes, Lordship. In my case also, Lordship, here the respondent is also with a child, Lordship, who is also not been taken care of by the father, Lordship.
Confirm. Not line to be a pago, not a pago, it does look a lot possible.
ইমান নেটটো কাম নকৰে ইয়াত।
একদম মনটো মানে
মই চব ছেভ কৰা নোলাল আৰু।
নাই এইটোৱেতো মেইন প্ৰব্লেম।
এই অজয় কুমাৰটোৰ পৰা কিয় লৈছিলো? মই এইকেইটাৰ লগতে আছে ন?
But tell me, Ms. Bachcharji, in absence of those formats,
Lordship.
whether the interim maintenance can be allowed to be continued?
No.
Lordship,
Because those
if,
things, we can understand that if it is not paid, that
Yes,
there will
Lordship.
be, the wife will be in a destitute position, right? That we can understand, but thing is this, if we have to consider in that aspect.
Lordship.
That is-
Lordship, if this be so, Lordship, if this be so, Lordship may put a particular time frame, Lordship.
That's what.
Within 1 month or
Otherwise, it
yes,
will be
Lordship,
difficult.
they have to complete all the
Otherwise, it will
process,
be
Lordship.
difficult. It will be whatever the order will be passed, it will be binding on the husband.
Yes, Lordship.
But thing is that it has to be, otherwise you will not able to see one hand, we are saying that
Yes, Lordship.
only one
Yes,
part has to
yes,
be there.
Lordship.
Then only interim maintenance has to be considered.
Yes, Lordship.
Until such decision, we are allowing you to quit. That will be, I think,
Yeah.
will not be inappropriate. So in that case, we may set aside these orders, directing both the parties to submit within a time frame. And the family court to decide both on the interim and the final.
Yes,
whatever.
Lordship.
On the basis of the Rajneesh husband has been followed by the case of Priti Aditi,
Adityan.
right?
Yes,
We
Lordship.
can to that extent, but we can give a time frame
Lordship.
that, yes, Ms. Jahan. Otherwise, we think it will not be proper because one hand we are accepting
Yes.
Rajneesh and Neha, at the same time allowing a wrong decision of a family court or order 125 proceeding, allowing the interim maintenance, which is not conformity with the.
And in the
judgment
name of
Rajneesh
Procedural,
and
Lordship, this will keep on continuing, Lordship. Oh, that's
Okay.
But my lord, the family courts, my lord, or the courts, learned court below in 125 proceeding. Recently, I have also filed 2 more cases, my lord. There is no that mandatory guideline framed. by
No,
the-
we have already noticed that our,
Yeah,
our
as a
registry has long back in November 2020, have immediately after the judgment of
My-
Rajneesh and Neha
my
have
lord.
communicated to all. We have the notification.
Yes, my lord, but.
But even today, Lordship, I was also attending in many cases, advising in many cases, Lordship. These things are never been, that means
Followed.
followed by any of them, even in Kamrup Metro, Lordship.
Spirit
We'll
technically.
get back to you on 12. These matters, there are some other matters are coming up tomorrow or something like that.
Lordship.
So let these matters all be fixed on 12.
My-
Just we have to have another information.
Lordship.
I'll try to get it
my-
today itself. Because we have the notification.
Right.
It is there is circulation to all the districts
Lordship. Lordship.
from our registry. We'll have it on 12, first year.
Lordship.
Obliged.
Deeply obliged.
Deeply obliged, Your Lordship.
Order is a-
My lord, in my case, item number 11, for instance, is in respect of these guidelines, but in this case, my lord, registers of warrant and NBW has already been. We'll consider you on 12. We'll pass, because every case will be dealt in separate, my lord.
My lord, my item is 49, my lord, supply list.
It is along with, yes, right. It came up day before yesterday, right?
Yeah, yes, my lord.
49 to- Take a look at DD book. Well, just seeking for information from our academy.
Lordship.
Because I look after academy, so I want to know what is exactly. So I am fixing it on 12. Let's take a look at it. Item number 12.
My pleasure. Lordship, may I have a look at the order dated 24/9/21. Petition is against my lord. Issuance of process and proceeding initiated on a private complaint. Then the
Mr. Barber, just take your seat. We'll just get back.
Lordship.
Let me go to the complaint.
Lordship will also go to the agreement. Now, Lordship may have a look at the agreement, which is the basis for all this.
Yes, Mr. Borber.
Lordship may kindly now have a look at page 22, agreement. Agreement.
Yes.
Now this agreement below, that the total consideration of money to be paid by the second party purchaser to first party is 5,50,000 only for the described in the schedule below for the land. Next page. That the second party has paid to the first party at the agreed amount as full and final payment for the land described. Yes, I admit. Then 3, this is important, my lord. Lordship may make a note of 3, that the first party has handed over the absolute and clear possession of the land to the second party. This is very important. Make a note. Tell you. So on that day, they paid me 5.5 lakhs by this agreement, and I handed over the absolute and clear possession of the land of the second party. This is signed by both. Then 4, that it is mutually settled that the first party seller will execute the register sale deed in respect of the land described in the schedule in favor of second party within a period of 6 months from the day executing signing. Then 6, my lord. Then 5, agreed that first party will make necessary arrangement for obtaining permission in respect of land described with active participation of the second party. Lordship may also note this particular sentence, active participation. That it is hereby agreed that the second party purchaser will bear necessary expenditure for stamp duty and registration and sale deed. This is also important. Some onus is also on them. That it is hereby agreed that after execution, it is found that there is any defect in it, so and so, so and so, so and so, so and so. In any, then the first party will be bound to return the entire money to the second party. This is the ultimate consequence. If there is a defect found in the title or anything like that, then I was bound to refund that money. So this being the sale deed. Normally, thereafter, normally for not giving to such agreement, the legal remedy is to file a civil suit for a specific performance. I take your lordships to section 10 of the Specific Performance Act. Section 10 and 11. May I read, my lord?
Yes.
Section 10, specific performance in respect of contracts. The specific performance of a contract shall be enforced by the court, subject to the provisions contained in subsection 2 of section 11 and section 14/16. Now let us see subsection 2. Section 11 says cases in which specific performance of the contracts connected with trust enforceable, except as otherwise provided, specific performance of a contract shall be enforced when the act agreed to be done is in its performance wholly or in part of the trust. Now, 2, contract made by a trustee in excess of his powers or in breach of trust cannot be specifically enforced. So there will have to be a trust given to me. Some property will have to be given to me on trust. Then 14, if the contract is not specifically enforceable, following contracts cannot be specifically enforced. Where a party to the contract obtains substituted performance of contract is not applicable. Contract performance which involves performance of a continuous duty which the court cannot supervise. A contract which is so dependent on the personal qualification of the parties that the court cannot enforce specific performance. A contract which is in its nature determinate. So this was the recourse for them in a situation like that. Now, forget about which party failed to perform their respective obligation. It was now within a couple of months after this agreement, I was detected with myeloid cancer. Lordship may have a look at page 24 and 25.
It's there. Okay. Yes, Mr. Baldwin.
My lord, page 24.
We have seen that.
Have a look at the date, because under the agreement, there was a period for 6 months to apply for sale permission and all these things. But 2 months thereafter, the below date is 28/9. Lordship has seen the date of the agreement. Date of the agreement was of 25/2/15. And then thereafter I was detected, and this is the certificate, also page 25. Another certificate. And thereafter, my lord, she has been under periodical treatment, as your lordship knows, and still fighting. Still fighting with the disease. Now, my lord, naturally, I couldn't pursue the process relating to the sale permission, etc. I'm a paragraph 2. I'm a lady from a very respectable family, senior citizen, retired as a professor HOD of an engineering college. I told him, my lord, opposite party, either you cooperate in doing all these land transfer works or take back your amount from me. I am ready. I have stated in my petition. But in 2019, my lord, she sends a legal notice to us under 80 CPC. And to my surprise, she not only asked for the return of 5.5 lakhs, she demanded another additional amounts of 2 lakhs, which was never paid, because there was no occasion for admitted additional amount to be paid. Lordship has seen the agreement, 5.5 lakhs paid, and then, my lord, immediately on that day itself, the possession was handed over. Knowing that, thereafter, also a legal notice was sent. I'll refer to their own complaint petition where they have stated it. And knowing that the period of limitation was over by 2018 for a suit, she then files a complaint, and lordship has already read this complaint. I am taking your lordship again to the complaint, please, my lord. Complaint petition with some twisted and baseless allegations against me. I will. Paragraph 3 is all right. It refers about the agreement. Then paragraph 6, it says, much time passed and still accused person has your lordship got it? Yes. Paragraph 6, complaint regarding any information about the process of obtaining sale permission, complainant met the accused at her residence at so-and-so, asked her regarding progress in the work of the said permission, And then the accused person told the complainant that since the land value has enhanced a great extent, she would have to pay 3 lakhs additional more of so-and-so on consideration. After lengthy negotiations, the additional amount was fixed at 2 lakhs. There is no basis, my lord, no receipt, no false. It is absolutely concocted. They didn't say on which date it was paid, in what mode of payment they paid it. So it was actually additional allegation made. And there was, the lordship has seen the agreement. There was no scope for making any additional payment. Agreement clearly says that 5 lakhs you hand over the possession today and which has been given, and both parties signed. Then 7 again, complainant respectfully state that in the month of 17 paid additional amount, but the accused person did not demonstrate the minimum courtesy to issue her a money receipt. This is no scope. Then, my lord, paragraph 9 also, complainant has paid additional amount and said that on a day her maternal uncle went to her residence. On the complaint said uncle again called, didn't pick up the phone, that the complainant states that, then thereafter, my lord, এইটো কথা ক'ত ক'লে TCPC নোটিছৰ এইখনটো কৈছে my lord, paragraph 11 kindly see. Complainant stated that since nothing positive was yielding from making phone calls and personal, complainant sent a legal notice to the accused person through her advocate on 9/4/19 by way of registered post, demanding handing over of the sale permission or alternately return amount of 7.5. It was never 7.5. As I said, then copies of the legal notice, postal receipt of the printout. So this was a notice under ATCPC. After more than 4 years of executing the agreement for sale, after this legal notice also, you didn't approach the appropriate court. Instead, this complaint, criminal complaint, has been filed, my lord, on some false and additionally false and concocted, my lord, storage. And the magistrate, my lord, took cognizance. Page 17C, kindly. There are only 2 statesmen under section 200 CRPC. He is interested, uncle. It is her statement. First, complainant's statement. We had purchased the plot of so-and-so, so-and-so, so-and-so. In the same, Nina Sharma, plot of land from Nina Sharma and Indrajit Sharma. This is not correct. I am the Indrajit Sharma, maybe my husband. He is not the owner. It is my land, my paternal land, and 5.5 lakhs. It is safe. Indrajit Sharma asked my husband. He is nobody to ask. It was between me and the third person. He was not even made an accused. An additional amount of the lot had increased. My husband agreed to pay so-and-so. We paid in the where, when, in what mode you paid. The accused is a fraud and had cheated many others in similar ways. Kindly have a note. Character assassination. Absolutely defamatory. She defied. We came to know that the accused is a fraud and has cheated many others in similar ways.
Okay. Let's hear Mr. Goswami.
Yes, my lord, let me finish for a while, my lord. Just for a while. Just for a while. Then, on this basis, it was issued. I approached this court and I have shown the order whereby this is. Now, 405, I will just show, my lord CRPC, kindly have a look at the 405, section 405. The offense is there. The panel section is, my lord, 406. See whether the ingredients are here. Assuming everything is right. Assuming everything, can you see the ingredients? 405. Criminal breach of trust.
Yes.
IPC. 405. Let's go to it. Whoever being in any manner entrusted with property, that is the prime condition precedent. I must be entrusted with a property. Is it a case agreement? Property has been handed over. or with dominion over property, other things are misappropriates or converts to his use that property, dishonestly uses or disposes of that property. Have I disposed of to anybody else? These are not even allegations. And the agreement says property was handed over. So therefore, I having handed over the possession of the land itself under the hand and seal of both the opposite party, me and the witnesses, and it was registered. There was no question of dishonestly misappropriating any property, and it is not a case where I was entrusted with any property, my lord. Absolutely case of civil nature, and it is a sheer abuse to put the accused person under harassment. And there are, apart from the contradictions of the self-versions in the complaint petition against the depositions under 220, I will just refer to two decisions if your lordship allows me. If your lordship allows. Magistrate took cognizance of 405, 406, my lord. The process was initiated. Case was registered. Page 21. Lordship will find the impugn order. Page 21.
We have seen that.
Yes. Hence, cognizance of offense punishable under section 406 is hereby taken against Dr. Nina Sharma after these two statements and on the basis of that complaint. My lord, 2009, volume 7, SCC 495. Devendra. Here I will take your lordship to paragraph 24. 24.
Yes.
It is an extreme case. Here, even charge sheet was filed on a GR case, not private complaint. Here, let us see what the Supreme Court said. Paragraph 24. Lordship got it? There is no dispute with regard to aforementioned propositions of law. However, it is now well settled that High Court ordinarily would exercise its jurisdiction under 420, 482 of the Code of Criminal Procedure. My petition is under both 482 and also 227 article. If the allegations made in the first information report, even if given face value and taken to be correct in their entirety, do not make out any offense. When the allegations made in the FIR or the evidences collected during investigation do not satisfy the ingredients of an offense, the superior court should not encourage harassment of a person in a criminal court for nothing. Then, my lord, 26. 26, it is a FIR is defined standard, therefore required to be applied. However, when materials are collected and charged, this is an extreme case, my lord. Even a charge sheet was filed in this Supreme Court case. Then, my lord, it is said, my lord, by the complainant here, paragraph 27. Submits that wrongful committed on part of the person may be a civil wrong or a criminal wrong, although an act of omission or commission on part of a person may give rise to both civil and criminal action. That was their contention. A distinction must be made between a civil wrong and a criminal wrong. When dispute between the parties constitute only a civil wrong and not a criminal wrong, the court should not permit a person to be harassed, although no case for taking cognizance of the offense has been made out. So these are the three paragraphs. Then, your lordship, 2011, volume 7, my lord. Joseph. Here I will, my lord, invite your lordship to straightway go to paragraph 14 to 17. paragraph 14. In this case, the complaint was in respect of 3 offenses. First, examine whether any of the ingredients under 406, 406 is also here, and 420 was there and 506 was there, have been made out to enable the court to take cognizance thereof against the appellant or not. Bare perusal of the FIR lodged by the complainant would indicate that he has got in touch with the appellant as to extend benefit of the appellant channel so-and-so TV to his own brethren residing in for the said purpose. He had met so-and-so, so-and-so. Then Lordship may come to, these were the particular facts of that case under 3 sections. 15. Criminal breach of trust is defined under, we are concerned with this. Criminal breach of trust is defined under 405 IPC and section 406 thereof deals with punishment to be awarded to the accused if found guilty for commission of the said offense, that is imprisonment for a time extending to 3 years with fine or both. Then section 420 IPC, Lordship may skip that. It was. Then section 506 deals with punishment for criminal intimidation. Lordship may skip that. Paragraph 16. Thus, from the general conspectus of the various sections under which the appellant is being charged and is to be prosecuted would show that the same are not made out, even prima facie from the complainant's affair. Even if the charge sheet has been filed, the learned single judge would have still examined whether the offences alleged to have been committed by the appellant were prima facie made out from the complainant's affair, charge sheet, documents, etc. or not. In our opinion, 17. The matter appears to be purely civil in nature. There appears to be no cheating or dishonest inducement for the delivery of property or breach of trust by the appellant. Present FIR is an abuse of the process of law. The purely civil dispute is sought to be given a color of a criminal offense to wreak vengeance against the appellant. It doesn't meet the strict standard of proof required to sustain criminal acquisition. In such types of cases, it is necessary to draw the distinction between civil wrong and criminal wrong, as has been succinctly held in this court in the Devendra, which I have already cited, my lord. The Devendra was relied on, 27 of Devendra. Then ultimately, paragraph 20, thus looking to the matter from all angles, we are considered opinion that the prosecution and the appellant for commission of the alleged offence would be clear abuse of the process of law, FIR under circumstances to be passed. Then, my lord, 1977, volume 2. Yeah, this is I have a copy. Here, yes, it is here.
Yes, you're relying on.
Hard copy. I have supplied that. Look, have a look at.
We have.
Yes. Three judges. Yes, Lordship may have a look at paragraph 7. 3 judges, Lordship. YV Chandrasul CJ, Senior Chandrasul J, PK Goswami and Singhal. The second limb of so the argument is that in any event, High Court could not take up itself the task of assessing, appreciating the weight of material on the record in order to find whether any charges could be legitimately framed and the respondents. So long as there is some material on the record to connect the accused with the crime, says learned counsel, the case must go on and the High Court has no jurisdiction to put a precipitate and premature end to the proceeding on behalf of their submission. In our opinion, is too broad. This, in our opinion, is too broad a proposition to accept. Then quoting 227, if upon consideration of the record of the case and the documents submitted and after hearing submissions, the accused and the prosecution in this behalf judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his persons. Then below, my lord, from below the second paragraph. In the exercise of this wholesome power, High Court is entitled to quash a proceeding if it comes to the conclusion that allowing the proceeding to continue would be an abuse of the process of the court and that the ends of justice require that both proceeding ought to be quashed, that the proceeding ought to be quashed. Saving of the High Court's inherent powers, both in civil and criminal matters, is designed to achieve salutary public purpose, which is that a court proceeding ought not to be permitted to degenerate into a weapon of harassment or persecution.
Yes.
So there I leave, and in this case also ultimately, case of the prosecution to which we have not applied our mind against so and so, the case against those accused must be material on appeal to. So paragraph 7, the ratio is laid down. Then my lord, 2006, volume 6. Here again, lordship may have a look at this. I can't get. Indian Oil Corporation. Here the principles are laid down, where in a series of cases, my lord, the settled position of the Supreme Court. Lordship may have a look at paragraph 9.
Yes.
Paragraph 9. This is the, my lord, the citation will be SCC.
2006, 6 SC.
Yes, yes. Yes, 736.
Right.
9. The principles relating to exercise of jurisdiction under section 482 of the Code of Criminal Procedure to quash complaints and criminal proceeding have been stated and reiterated by this code in several decisions. All these decisions are here. I have also placed my certain decisions. Next. The principles relevant to our purpose are, kindly see what are the complaint can be quashed where the allegations made in the complaint, even if they are taken at their face value and accepted in their entirety. Extreme position. Do not prima facie constitute any offense or make out the case alleged against the accused. I fall in here. For this purpose, the complaint has to be examined as a whole, but without examining the merits and allegations. Neither a detailed inquiry, nor a meticulous analysis of the material, not an assessment of the reliability of genuineness of the allegations complaint is warranted while examining prior for quashing of a complaint. Complaint may also be quashed where it is clear abuse of the process of the court, as when the criminal proceeding found to have initiated with malice and malafide for wreaking vengeance or to cause harm, or where the allegations are absurd and inherently improbable. The power to quash shall not, however, be used to stifle or scuttle a legitimate prosecution. The power should be used sparingly. Then Roman 4, complaint is not required to verbatim reproduce the legal ingredients of the offense alleged if the necessary factual foundation is laid in the complaint merely on the ground that a few ingredients have not been stated. Proceedings should not be quashed. Quashing the complaint is warranted only where the complaint is so bereft or even basic facts which are absolutely necessary for making out complaint. So in my case, the basic allegation is section 405 IPC and the ingredients are not fulfilled. There will have to be a property entrusted to me and I must dispose of that property in breach of the trust. Then Roman 5, a given set of facts make out purely a civil wrong, purely a criminal offense, or a civil wrong as well as criminal offense, a commercial transaction of a contractual dispute apart from furnishing cause of action, seeking remedy in civil law may also involve criminal offense, as the nature and scope of a civil proceedings are different from the mere fact that the complaint relates to a commercial transaction or breach of contract, or for which a civil remedy is available or has been availed, is not by itself a ground to quash criminal proceedings. Test is whether allegations in the complaint disclose a criminal offense or not. I highlight this sentence. While on this issue, it is necessary to take notice of the growing tendency in business circles to convert purely civil disputes into criminal cases. It is obviously on account of a prevalent impression that civil law remedies are time-consuming and do not adequately protect interests of the lenders, creditors. Such tendencies seem several family disputes also leading to irretrievable breakdown of marriage families. There is also impression that if a person could somehow be entangled in a criminal prosecution, there is likelihood of imminent settlement. Any effort to settle civil disputes and claims which do not involve any criminal offense by applying pressure for criminal prosecution should be deprecated and discouraged. It is to be seen if a matter which is essentially of civil nature has been given a cloak of criminal offense. Criminal proceedings are not a shortcut or the other remedies available in law. Before issuing process, a criminal court has to exercise a great deal of caution. For the accused, it is a serious matter. This court has laid certain principles on the basis of which High Court is to exercise jurisdiction under 482. Jurisdiction under this section has to be exercised to prevent abuse of the process of any court or otherwise to secure ends of justice. Then the last one, my lord, Anand Kumar Mahatta, 2019 SC, my lord. I have the copy.
Yes.
So this I have given that one, my lord. Anand Kumar Mahatta. There, my lord, lordship may it discussed various cases, my lord. The ratios of some of the cases I cited. Paragraph 15. Paragraph 15. Yes, I think this is my lord, 2019 Supreme Court 210. AR 2019, not SCC, my lord. AR 2019 Supreme Court 210. Paragraph 15. First, we lots of got it.
Yes, sir.
Paragraph 15. First, we would like to deal with the submission of learned senior counsel for the respondent to that once the charge sheet is filed, petition for quashing, FIR is untenable. We do not see any merit in the submission. Keeping in mind the position of the court in Joseph, I have cited Joseph. In the case of Joseph, this court, while deciding the question where the High Court can entertain 482 petition for quashing, when the charge sheet was filed by the police during the pendency, it was observed. Then paragraph 16 of Joseph is quoted here. Then paragraph 19. Lastly, 19, my lord. Lastly, we find that FIR and the charge sheet essentially charge the petition for an offense under section 406, criminal breach of trust. In 2013, 10 it relied. It has also, my lord, referred to 2000 volume 2, where an offense is made out under 40C. It is necessary to refer to section 405 and 6 of the IPC in order to ascertain whether in the facts and circumstances of the present case, offense under 406 is made out against the appellant. Now here, 405 is quoted. Whoever brings any manner entrusted with property, I have already referred, it's in from CRPC. Here the explanation is also given. Then paragraph 21. Paragraph 21. 21, Lordship. The essence of offense lies in the use of property entrusted to a person by that person in violation of any direction of law or legal contract which he has made during discharge of such trust. In the present case, amount of 1 crore was paid by complainant respondent to the appellants as an interest-free deposit on the signing of the agreement. It was liable to be refunded to the complainant simultaneously on handing over possession of the area of the owner's share to the owner. Then 23. We just find it is not possible to hold that amount of 1 crore which was paid along with the development agreement as a deposit can be held and as a deposit can be said to have been entrustment of property, which has been extreme position, which has been dishonestly converted to his own use. Dishonestly converted to his own use, or disposed of in violation of any direction of law or contract by the appellant. Going by the agreement, the amount has to be returned upon handing over the construction area of the owner, which admittedly has not been done. Most significantly, the respondent who has not demanded return of amount at any point of time. In fact, it is specific contention of the respondent he has not demanded amount because the agreement is still in subsistence. We do not see how it can be contended by any stretch of imagination that appellants have misappropriated the amount or dishonestly used the amount contrary to any law or contract. I highlight this. In any case, we find that the dispute has contours of a dispute of civil nature and does not constitute a criminal offense. 24. Having given our answers consideration, we are of the view that assuming that there is a security deposit, he has misappropriated the dispute between the two parties can only be a civil dispute. Extreme position. Then Indian Oil Corporation, I cited my lord already. And 2006, it says, my lord, the principles on the basis of which. Then paragraph 28. Paragraph 28. Here, my lord, paragraph 7 of 1977 is relied on again. Karnataka versus Monuswamy. Court proceeding ought not to be permitted to degenerate into a weapon of harassment or prosecution. In a criminal case, the veiled object behind a lame prosecution, the very nature of material on which the structure of prosecution rests and the like would justify the High Court in quashing the proceeding in the interest of justice. We find that the prosecution is mala fide untenable. 29. We have therefore no hesitation in quashing the FIR. And that's it. So therefore, concluding, Lord Side, this is really an abuse. Assuming the complaint on its face value, as the Supreme Court said, I submit that none of the ingredients of section 406 is fulfilled or can be attracted. And this type of my lord criminal litigation has been discarded and denounced time and again by the Supreme Court. So is my case, my till that it is under a stay proceeding. That's all. Sorry.
Yes, Mr. Swami.
Look, since my learned senior friend has already taken your lordship through the facts, I will only request your lordship to kindly note down what are the aspects admitted and what are the facts disputed, my lord. My lord, it's an admitted position that there had been an agreement for sale, there was a proposal for sale, and some money, an amount of 5.5 lakhs was received by the petitioner, my lord. That is not disputed. Only thing is disputed is that payment of the receipt of the additional money. Now, I can understand that I have a heavy burden on me, but I'll discharge it, my lord. Now, the petitioner is submitting that I had not cooperated with the sale permission process. But whether there was any notice issued to me, there is no material, my lord, with the petitioner. Further, my lord. Only because, my lord, I'll rely on some Supreme Court judgments, my lord, only because there is a civil outfit. Can it totally denude the criminal outfit, my lord? Can the criminal aspects can totally be denuded, my lord? My lord, I'll just like to rely on 3 judgments, my lord. First one, my lord,
1993, 1999 CSCC 259, Rajesh Bajaj.
Yes.
Lordship may kindly strictly come to, I'll rely upon paragraph 6, 9 and 10, Mother. I'm reading paragraph 6, Mother. Learned judges of the High Court have put forward 3 premises for quashing the affair. First is that the complaint did not disclose commission of any offense of cheating punishable under section 420 of the Indian Penal Code. Second is that there is nothing in the complaint to suggest that the petitioner had a dishonest or fraudulent intention at the time of at the time the respondent exported the goods worth so and so. There is also nothing to indicate that the respondent, by deceiving the complainant, induced him to export goods worth rupees so and so. The third is that on the face of the allegations contained in the complaint, it is purely a commercial transaction, which in a nutshell is that the seller did not pay the balance amount of the goods received by him as per his assurance. Now, paragraph 9. It is not necessary that a complaint should verbatim reproduce the body of his complaint, all the ingredients of the offense he is alleging. Nor is it necessary that the complainant should state in so many words that the intention of the accused was dishonest or fraudulent. Splitting up of the definition into different components of the offense to make a meticulous scrutiny whether all the ingredients have been precisely spelled out in the complaint is not the need at this stage. If factual foundation of the offense has been laid in the complaint, the court should not hasten to quash the proceedings during the investigation stage merely on the premise that 1 or 2 ingredients have not been stated with details. For quashing an affair, a state which is permitted only in extreme rare cases, my lord, the information in the complaint must be so bereft of even the basic facts which are absolutely necessary for making out the offense. In the state of Haryana versus Bhajanlal, this court laid down the premise on which FIR can be quashed in rare cases. The following observations made in the aforesaid decisions are sound reminder. Look, Bhajanlal's case has been quoted, my lord, paragraph 10. Then your lordship may kindly come to paragraph 10. It may be that the facts narrated in the present complaint would as well reveal a commercial transaction or money transaction. But that is hardly a reason for holding that the offense of cheating would elude from such a transaction. In fact, many cheatings were committed in the course of commercial and also money transactions. One of the illustrations set out under 415 of the Indian Penal Code. But next, I would like to rely upon another judgment, 1999 8 SCC 686. Paragraph 7 now. Lordship will come to paragraph 7. Time and again, this court has been pointing out that quashing of FIR or a complaint in exercise of the inherent powers of the High Court should be limited to very extreme exceptions. Right, state of Haryana versus Bhajanlal and Rajesh Bajaj. Rajesh Bajaj, I have just referred to. Madam. In the last referred case, this court also pointed out that merely because an act has a civil profile, it is not sufficient to denude it of its criminal outfit. We quote the following observations. Paragraph 10. It may be that
already pointed out, right?
Yes, my lord. Then your lordship will kindly come to paragraph 10. Learned single judge has accepted the alternative contention advanced by the respondent pertaining to want of jurisdiction for judicial magistrate of first class, Gandhigam, in respect to offence alleged. Lord, in this case also, it has been held that merely because there is a civil profile, it cannot denude it of its criminal outfit. But I'll refer to rely upon another decision of this Honorable Supreme Court, my lord. 2000, Volume 3 SSC 269. Paragraph, I'll rely upon paragraph 1 and 17, my lord. Paragraph 2 and 17. Exercise of jurisdiction under the inherent power as envisaged in section 482 of the code to have the complaint or the charge sheet quashed is an exception rather than a rule, and the case for quashing at the initial stage must have to be treated as rarest of rare so as not to scuttle the prosecution. With the lodgement of the first information report, the ball is set to roll, and thenceforth the law takes its own course and the investigation ensues in accordance with the provisions of law. The jurisdiction as such is rather limited and restricted, and its undue expansion is neither practicable nor warranted. In the event, however, the court on a perusal of the complaint comes to a conclusion that the allegations leveled in the complaint or the charge sheet on the face does not constitute or disclose any offense as alleged, there ought not to be any hesitation to rise up to the exception of the people and deal with the situation as is required under the law. Frustrated litigants ought not to be indulged to give vent to their vindictiveness through a legal process, and such investigation ought not to be allowed to be continued since the same is opposed to the Constitution. Paragraph 17, my lord. On a careful reading of the complaint, in our view, it cannot be said that the complaint does not disclose the commission of an offense. The ingredients of the offenses under section 415, 418, 420 cannot be said to be totally absent on the basis of the allegations of the complaint. We, however, hasten to add that whether or not the allegations in the complaint are otherwise correct has to be decided on the basis of the evidence to be laid at the trial in the complaint case, but simply because the fact that there is a remedy provided for breach of contract, that does not itself clothe the court to come to a conclusion that civil remedy is the only remedy available to the appellant herein. Both criminal law and civil law remedy can be pursued in diverse situations. As a matter of fact, they are not mutually exclusive, but clearly coextensive and essentially differ in their content and consequence. The object of criminal law is to punish the offender who commits an offense against a person, property, or state for which the accused, on proof of offense, is deprived of his liberty and in some cases even his life. This does not, however, affect the civil remedies at all for suing the wrongdoer in cases like arson, accidents, etc. It is an anathema to suppose that when a civil remedy is available, a criminal prosecution is completely barred. The two types of actions are quite different in context, scope, and import. My lord, in my case, as my learned senior friend has submitted before your lordship, my lord, section 405, his submission is that no property was delivered. My lord, in my case, 405 does not necessarily mean that the property should be an immovable property. In my case, the property was the money, my money, which was handed over to him. What he has done with the money. And moreover, there was an additional payment of rupees 2 lakhs, my lord. I'll discharge my burden of proving it at the time, at the trial, my lord. But does it warrant for nipping this case at this stage, my lord? Only cognizance has been taken. Let him argue on the charge, my lord. If charges are not framed, then he'll be discharged thereupon, my lord. He has taken my money. He has not done what he had promised to do. He has not even asked for me, for my cooperation, my lord. And I have, and insofar as the possession, delivery of possession is concerned, my lord, I have filed an affidavit in this case, my lord. I have denied it, my lord. Paragraph 6 of my affidavit in opposition in this case, my lord. Had the possession been delivered, I would not have been before the court of law, my lord. The question of possession does not come, my lord, because no sale was affected. Only money was taken. So I'll conclude that, my lord, this is not a case which should be nipped at the bud, my lord. Let him face the trial, my lord. There are sufficient ingredients for the offences and charges are yet to be framed, my lord. At least at this stage, it should not be nipped, my lord. That's all. My lord, I would just like to add, my lord, Lordship will kindly see the order of cognizance, my lord. It says that statements of 3 witnesses were taken. The complainant was examined under 200 and 2 other witnesses under 202. My lord, the statements of those witnesses are not before your lordship. My lord, I have a very good case, my lord, for trial. I will be able to prove it. I'm confident that I'll be able to prove it.
I don't think, my lord, I give any reply, accepting the citations, Rajesh Bajaj. In that case, Supreme Court says, out of 4 ingredients, if 1 or 2 are not there. In my case, not a single ingredient is fulfilled for 406. That is number 1. And property amounts to money also, not only landed property. I have cited that course, where 1 crore was paid in advance by a company for a deal, my lord. And their court said nothing doing. 406 is not attractive. Then inherent power, my lord. Lordship has the inherent power. Under, my lord, 482. Supreme Court has said, my lord, there is also a power, my lord, under 227 article. Let us not forget that too also. Protect from the abuse of law, number 1. And undue harassment in the garb of a criminal complaint with respect to civil wrong, which has been consistently said by the. That's all, my lord. And about handing over of the handed property, she has signed the agreement. I have shown the agreement, lordship. Both parties have signed that it has been handed over. That's all, lordship.
Yes, Ms. Jahata.
A prima facie, of course, you don't have to use it. Prima facie, of course, the complaint shows ingredients of 406. In fact, a learned senior friend said that it was handed over. But then without the sale permission and all, how can a land be handed over to the party? Subject to correction. Possession also, without the ownership.
Not right title.
So,
Cannot be on assumption.
Hmm.
Agreement clearly reveals that the
Hmm. Agreement reveals such
first
as
party has handed over absolute and clear possession of the land to the second.
clear possession. So without the ownership, possession will not come.
It is under her signed signature also.
The entrustment of the property, which on basis of getting that property, it's somehow misuses for his own benefit or other purpose, that is 405. Whether the ingredients of 405 is there.
Because what we need to see in a quashing application is prima facie whether the ingredients are there. In the complaint petition, there are ingredients because
The complaint petition, there is indicated to the extent that money of this amount. Let us not go to the dispute of another two. Let us say
Ah.
5,50,000.
okay, 5,50,000.
And the self-presentation has not been paid.
Yes.
Has been
Mm.
put under the contract. That
Nothing was communicated to her.
And there is no, in the complaint, there is no mention that property hasn't been handed over in spite of taking it.
Hmm.
There is
Nothing.
nothing.
She did not say anything.
Only it is the sale permit.
Only about sale permission.
The sale permission was not obtained.
Hmm.
405 will.
Sale
40
permission,
permission is 405 is totally the entrustment of the property.
entrustment. Entrustment of money was there. She had already given.
No.
But if the sale is not permitted, if sale permission is not obtained, then the possession will also have be handed, has to be handed back. I mean, and nothing fruitful will come.
Now, see, what the complainant is asking to return back the money of 5,50,000. But she is silent with regard to that she is sitting over there, having the possession over the property. There is no mention in the complaint.
Hmm.
That the accused have already taken the money but did not hand over the property. And also have not obtained the sale permit. So the money is with the accused and without any such benefit. That is something different. That is not. Now,
And she is trying to sell it to a third party also. That averment is also there.
so there, but thing is this, basic
406.
406. One thing in the judgment of Indian Oil Corporation,
Yes, refer.
it was all the ingredients of section 405 was
Has to be
discussed in
there.
that judgment. Okay. But what happened in the High Court in that matter have quashed the proceedings.
Oh.
Then after going through the entire aspect, the Honorable Apex Court found only the ingredients of section 405 were not clear.
That's all.
So could not have been prosecuted under section 405.
Hmm.
But after going through everything, the Honorable Apex Court set aside the order of the Honorable High Court, saying that during the process they found that there are ingredients of section 415 and 425.
That's cheating.
So that is why the Honorable Apex Court directed reopen the matter, directing the concerned magistrate to proceed against the
Cheating, but not misappropriation.
not under 405.
405.
406 is the punishment. It should go into the 415 and 4. That is why in that case,
It's on facts again. Here,
that's right. So
admitted fact that money was given. 2 lakhs we will leave
So,
aside.
you can see from this agreement itself, the money was obtained and land was handed over. But sale permission was not.
Given.
That is it. Which was, as per the agreement, it was the duty of the seller
Seller.
to obtain.
That is, accused has to do it. It was the responsibility of the accused.
Now, non-obtaining of the sale permission.
The entire agreement will go.
405 or 406, because having the already property.
The giving possession will not matter if sale permission they cannot receive, they cannot obtain. Difficult.
Agreement is there.
State submission, I will not comment. It is state government submission, prosecution between private complaint and me.
No, we are not just asking only because we are been adjudicating the matter that much.
No.
We cannot be on an assumption, right? But to that extent, yes, the accused, the seller, did not obtain the sale.
But sale permission takes time. We all know it takes long.
It did not even apply.
Yes, that we don't know.
In the petition, in the complaint.
That is what is written. That will amount to some kind of a what this here, 406, 405. She did not apply. She had given the possession.
Charge can always be altered.
Charge can always, that is also there.
Okay, we'll
But
look into it.
cognizance is taken, charge can.
Only on 406.
406 only.
But it can always be altered, my lord.
If we see the ingredients of 405, whoever being in any manner entrusted with property. So she was given the money. Of course, she has handed over, that is different, but she was entrusted with the money and the agreement has to reach its final
That's what in
position.
the apex court in the case of Indian Oil Corporation that was looked into. 1 crore money was already advanced. Not happening. There,
Then also.
405. We'll look into it.
Not sure.
Because you see, facts of the case differs. The advance only allows us to go to a particular extent. We'll look into it. Third, MS, so Mr. A. Borboral and its senior counsel.
Assisted by Andy.
MS and A. London Counsel for the division. And MS Jahan, the representative of the prosecutor, Sam. For the state respondent number 1. Also heard Mr. D. Goswami, London Counsel for the opposite party number 2/complainant. Twenty-fifth.
Obliged.
मेंशन कुछ नहीं फिर मेंशन कर देना चाहिए 30 तो हमारे बड़े रेडी से 13 actually 32 is you don't need it 13 to like mention just on repair of the council for the petition. Material drafted for the it will occupy a total which
May please, Lordship. Lordship, as per the last order, Lordship, petitioner has paid 30,000 on 16th of last month, and on 30 he has paid 25,000. So area is clear.
just
In the last order, he's been directed to pay the pending area amount to his minor daughter.
None appeared for the petitioner on call.
So I have a prayer. So kindly, I am praying for a direction to him for continuance of the monthly maintenance.
What's your good name?
A Borwa, Anjali Borwa. दादा नाही दादा खूप मिस होईल दादा हो पैसा दिसेल
Or Mr. Bulwal, if you granted additional public prosecutor Assam for the opposite party number 1. And I'm A. Burwa, right?
A Borwa.
Grant counsel for the opposite party.
Yes, one number 2.
On instruction. Ms. Burwa submitted. That on which dates they have been deposited?
16th of last month, 30,000. And on
16th of August.
August and 30, 25,000.
That on 16/08/2024. Automatic sentence that the petitioner on 16/08/2024 submitted deposited rupees 30,000. And on 30/08/2024 deposited another amount of rupees 25,000. Thereby deposited altogether 55,000, inclusive of area amount of rupees 50,000, area amount of maintenance. And monthly maintenance of rupees 5,000 for the month of July 2000. This, there is a direction for payment of was there some stay order passed earlier?
No, no any stay order passed in this case. There's no any stay order.
List again on. List on. 28.
20,
20.
20. You're not date. It's discussion.
Monthly. Respondent. Opposite person.
Always.
The matter party to dispute about student properties claim with in-laws. My lord, LCR was called for pass that is available. Lordship, it required some hearing, my lord. If lordship, please to fix a date for hearing, my lord. Or there are some legal issues are there, my lord.
Lordship, I am appearing for the wife petitioner complainant in this case. See, the in-laws petitioner challenge the proceeding before this honorable court under 482 of the CRPC Lordship. The street and properties which are in custody of the in-laws petitioner, that was challenged by the appellant before this honorable court, Your Honor. The search warrant was issued by the learned trial court. That was pending disposal before the learned trial of Kamrup matter at Guwahati. That proceeding has been challenged before this honorable court under 482 of the CRPC Lordship.
Okay, we'll come back at 2.
Adjournment. Late.
Yes, Lordship.
Let me allow to place my case or Lordship fix the matter.
Yes,
for
yes,
the-
yes.
Yes, ma'am.
She has been asking for the Sridhar,
My-
which you are objecting.
Yes, my lord, question is that, my lord, it is like not a case of Sridhar, straightway. Lordship, just let me allow to place the facts. What is their petition, Lordship? Just have a look, page 17. Page 17 is an application which they have preferred under section 190, read with section 93 of the CRPC. Now, Lordship, straightway, the projection of their case is this way, my lord. Page 21, paragraph 9. That life of the complainant becomes miserable at the hands of her husband on 18/7/2018 without any reason. The husband of the complainant started verbally abusing, physically assaulting the complainant, and her husband also spitted on face of the car in front of the accused and also threw out the complainant from her residential flat. And finding no other way, the complainant came to her parents' house. The complainant left all her stolen properties at the house of the accused person. Now, Lordship, kindly see paragraph 11. A divorce case was filed, which was subsequently withdrawn because of the death of the deceased husband. Now, paragraph 12 is relevant. That the complaint stated that the accused person did not allow the complainant to take her street and articles and belonging from the matrimonial house. Now, this is the allegation. Now, Lordship, can see the list of articles. These are the list of articles which they have annexed with the petition, which start from page 26. Now, the whole trouble is, my lord, about the account that contained in page 30, reference is there. Page 30, my lord. My lord, 30 page says about, Lordship, it's a very clear-cut case which has been otherwise moved in different direction. ICICI Bank joint account. Lordship, there is a clear-cut mention about joint account, my lord. Page 30. Now, once there is a joint account, my lord, a person expired, my lord, the first necessity is about, my lord, get to succession certificate. That has not been obtained, but instead of that, my lord, the attempt which was made otherwise by the learned court below, the same order has been, my lord, revised. Lordship, kindly see page 50. The first order which was passed in their favor in respect of recovering of the student article. Start from page 49, order dated 9/12/2022. And, my lord, the relevant part in page 50, last paragraph. May I read, my lord, page 50? Last paragraph. Issue search warrant to the officer in charge, Bhangagar PS, authorizing him to conduct a search plate number so and so, to recover the listed article belonging to the complaint as per her identity, except the ICICI Bhangagar Bank joint account bearing number so and the joint locker bearing number 70 with the same bank. There is a clear-cut direction by the court itself restraining that this issue has not been dealt with. Now, subsequently, on the same set of facts, my lord, another order was passed, which is very surprising, my lord, that containing page 52, impugning order 16/6/2023. Page 52, last paragraph, my lord. Upon considering the material on record and submission of the both sides, I see prima facie ground as to the retention and possible misappropriation of the Sridhan article of the complaint by the accused, As such, I deem it proper to issue a general search warrant for searching the plate number so and so and so. Issue search warrant to the officer in charge of Bhangar PS, authorizing him to conduct a search of the plate of the accused at the above mentioned address and to recover the key of the joint loan. So and so. Earlier order says, no, don't do that thing. Subsequently, my lord, the same set of facts, there is no any change of the, my lord, the subsequent development, and another order was passed. It's not a contradictory order, my lord. How the learned court will pass on same set of two order, my lord. Now, the lordship can see that the locker is why come into picture, my lord. My lord, earlier they have filed a, my lord, divorce case. Lordship, can you have a look, page 31. Page 31 is a divorce case which was filed in the year 2019. Not a single whisper, my lord. Now, afterward, my lord, kindly see that once, my lord, she withdrew this case, my lord, after expiry of her husband, my lord, she came with another case of complaint which has been filed against me. And, my lord, based on that, my lord, cognizance was taken under section 406 and 420, my lord. No interest into me, my lord. No cheating from inception. Despite of that, my lord, cognizance was taken, someone was issued to me, my lord. Is it a bad cognizance, my lord? Now, lordship, the application of law is what? My lord, in such a situation, my lord, once she has filed the divorce case, my lord, the Hindu Marriage Act section 27 demands that in case of recovery, my lord, the petitioner can approach before the family court seeking her recovery of Sridhar, my lord. My lord, can you have a look, my lord, Hindu Marriage Act section 27. No such attempt was ever made during that continuance of proceeding. My lord, may I read 27, my lord? Hindu Marriage Act. But section 27 says, disposal of property in any proceeding under this act, the court may make such provisions in the degree as it deemed just and proper with respect to any property presented or at about time of marriage which may belong jointly or both the husband and the wife. Therefore, my lord, she could have, my lord, at the time of filing divorce case, my lord, by inviting section 27, she could have claimed, my lord, about Sridhar. No whisper in the petition. Now, afterward, my lord, while the application was moved, my lord, there is not a single line, my lord, added thereon, saying that any articles which in the nature of Sridhar lying in locker, my lord. This whole story has been presented afterwards, my lord. Now, lordship, kindly see another application. Section 14 of the Hindu Succession Act, my lord.
You are relying on section 27 of the Hindu Marriage Act?
Yes, my lord. Another section, my lord, Hindu Succession Act, my lord. Another law, that is Hindu Succession Act, section 14.
Section 14?
Yes, my lord. Hindu Succession Act that dealt with about property of a female Hindu to be her in her absolute property. Section 14. Property of a female Hindu to be her absolute property. Any property possessed by female Hindu, whether acquired before or after commencement of this act, shall be held to be her a full owner thereof and not as a limited owner. Therefore, my lord, in case of suppose 14 come into play, my lord, then she could have, my lord, raised the issue for the purpose of seeking succession certificate. And my lord, already a succession case is pending before, my lord, Tinsukia court as on today, my lord. Now, until the issue has been decided that who are the actual successor, my lord, the bank definitely will not allow, my lord, to open the locker, my lord. It's a joint locker, my lord. Now, second aspect, lordship, that respondent has already got married to another person, my lord. Now, another act, my lord, Hindu Widow Remarriage and Property Act 1989. It regards that after getting married, my lord, the lady has no any right over the property of her husband, my lord. The
Of her
section,
husband, but what about her Sridhan from the first marriage?
my lord,
Of her husband, but
Yeah.
what about the property of her, that is her Sridhan, prior to her second marriage?
second marriage, my lord, she has already got everything, my lord. There is nothing, my lord.
What about the Sridhana?
Still, the list which they have enclosed, they do not have any objection. Lordship kindly see the list, everything they have recovered, my lord. Now, afterward, they coming with a claim that certain articles lying in the locker, my lord. Lordship, just have a look for a petition for a moment, my lord. Start from page 17. This is the petition, my lord. There is not a single whisper that anything lying in the locker. Par contra, my lord, it's stated that there is a joint account that containing page 30, my lord. And based on this petition, my lord, the respective order was passed. My lord, she has recovered all the articles. Question is that, my lord, the same court on the same set of facts cannot pass two different order, my lord. And the learned court below even not ascertain that whether right accrued her in favor of respondent in absolute or not, that mother and father is still alive, my lord. They have also equal share in respect of that locker, my lord. And for that purposes, my lord, succession certificate necessary, my lord. My lord, my humble submission is that, my lord, this lady in the name of Sridhan is harassing that all my lord in-laws. And second aspect, my lord, since 2019, she has no any claim about Sridhan during the stage of divorce, never invited any application section 27. At the stage of taking cognizance, my lord, she has already got a favorable order, articles recovered. Afterward, my lord, she attacked about the issue of local. There must be a pleadings, my lord. In petition, there is not a single pleading, single word is there, my lord. Page 70. About that, any article lying in the locker, my lord. The certain norms, my lord, bank will never allow, my lord, if there is joint account. Until there is succession certificate, once person expired.
Okay, yes, what do you have to say, Mr.
Lordship. Lordship, I am appearing for the opposite party wife, Lordship. Lordship, kindly peruse the page 19. Internal page 3, Lordship. Paragraph number 3. That after the marriage, the complainant was taken to the house of the accused person. Complainant took all Sridhan properties with her. Thereafter, the Sridhan property were handed over to the accused person in her law's house and entrusted those properties to the accused person to keep the look after the safe custody of the same. There is clear disclosure of offense, Lordship. Now, Lordship, kindly come to page 22, Lordship. Paragraph number 10, internal page 6. That the complainant states that she, along with her husband, has also joint account bearing source ICI Bank Bhangagar branch and a locker bearing number 70 with the said bank. Lordship, all the ornaments which are mentioned in the list were kept in that locker. Further, Lordship, in paragraph number 12, that the complainant states that accused person did not allow the complainant to take her Sridhan article and belongings from her matrimonial home. Moreover, the Sridhan articles of complaint are now within the unlawfully custody of the accused persons. And in spite of repeated requests of the complainant and her parent, the accused person are not returning the same to the complainant, and the accused person are utilizing those articles. Now, Lordship, kindly turn to page 23, internal page 7, paragraph number 14. That on 2/5/2022, the complainant along with her mother went to the house of the accused person and asks the accused person to return the Stridhan properties. Both the accused persons use filthy language upon the complainant on her mother. The accused person refused to hand over the Stridhan properties. The accused person threatened the complainant and her mother not to come in future for the Stridhan properties. Now, you will kindly see the paragraph number 16. That the complainant would like to state that some of the Stridhan property have already been misappropriated by the accused person, and there is every chance of misuse the other Stridhan property, and hence your humble complainant. Your Honor, complainant clearly disclosed, Your Honor, all the Stridhan properties that are mentioned in the list. Moreover, when the first search warrant was issued by the honorable trial court, Lordship, when she could have recovered only her belongings, not the ornaments, Lordship. Ornaments are kept in the locker. For that, the search warrant was issued by the learned trial court. And moreover, Your Honor, the appellant has suppressed the material facts regarding the petition which has been filed by the accused person. In that petition, Lordship, the accused has admitted that yes, we will hand over your Stridhan properties. But in spite of that, Your Honor, they have not handed over, Your Honor. Only the clothes and belongings were could have recovered on when the first search warrant issued by the learned trial court, Lordship. So far as that ornaments is concerned, gold ornaments of the petitioner wife is concerned, Lordship, that could not be recovered. Kindly see, Your Lordship, kindly see the petition which has been filed by the accused person, that the accused further states that accused person don't have any dominion over the articles. If any lying in the said locker, as alleged by the complainant. Further, the said locker being jointly operated by the complainant with her deceased husband can be opened only observing the due process of law. They herself admitted in their petition that they do not have any dominion over the locker, which has been maintained by the deceased husband and the present petitioner, Lordship. Now, Lordship, the first order when that was passed by the learned trial court, that is my learned friend is saying that there is no contradiction at all, Lordship. And further, they are not approaching this honorable court with clean hands. They suppress the material facts. That they even 3 times they have admitted in written that they will hand over all the gold ornaments and belongings of the petitioner wife. But in spite of the repeated order by the learned trial court, Lordship, they have not handed over the same. And so far as Lordship, the civil case is concerned, the divorce petition, when the divorce petition was pending, the husband was expired. And so that petition was withdrawn by the petitioner wife, Lordship. The divorce decree was not passed, Lordship. Lordship, kindly see the order first order that was passed on 9/12/2022 at page 49. A detailed order was passed by the learned trial court considering all the material facts and records, Lordship. There is no illegality, infirmity in the order passed by the learned trial court, Lordship. The complainant is present in the court, Lordship, along with her learned counsel. The accused person are absent, Lordship. Now, that on page 49, last paragraph, upon perusal of the complaint filed under section 406/420 of the IPC, and upon going through the material record, transpired that there are specific allegations against Sri Kulandar Kumar Nath and Srimati Susma Chetri. Moreover, Your Honor, Srimati Susma Chetri is not the biological mother of the deceased husband. She used to work as a servant. For refusal to return the criminally misappropriating the listed Stridhan article belonging to the complainant, which were given to her at the time of her marriage with the son of the accused person, namely late Manjit Nath. The complainant gave details of the particulars of the Stridhan properties and prayed for recovery of the same by issuance of search warrant under section 93 of the CRPC. sufficient ground to cognizance against the two accused persons who are in lodge of the complainant. The learned counsel for the also submitted that if the listed Stridhan article not sooner recovered, then there is every possibility that there might be disposed of by the accused person, which would cause irreparable loss to the complainant. In reply to the so-called notice issued, the accused person denied to retain the misappropriated property. Is also submitted that complainant took with her Stridhan property at the time of departure from the matrimonial home. Upon considering the material record, the entire facts and circumstances, I see prima facie ground as to retention, misappropriation of the Stridhan properties of the complainant by the accused. As such, I deem it proper to issue general search warrant for searching the flat number so-and-so at Christian Basti Guwahati. Issue search warrant to the officer in charge, to recover the listed article belonging to the complainant per identification asset the ICICI Bank Bhangagar being locker number so-and-so. Only locker being, lordship, that was kept in abeyance. Only belongings were for search warrant was issued by the landed trial court. The complainant is hereby directed to remain present during the search identification. The officer in charge is further directed to make over the Stridhan article identified by the complainant into her custody and indemnify the bond of 45 lakhs. Lordship, only search warrant was issued for the recovery of the belongings of the complainant wife. And in the next order, Lordship, when the house was searched and the belongings were recovered, the ornaments could not be recovered. For that, another petition was made before the landed trial court, and Honorable Landed Trial Court, Lordship, passed the order on 16/6/2023 at page 52. By petition number so-and-so, the complainant has stated that her gold ornaments constituting the part of the Stridhan article have been kept in the bank locker number 70 of ICICI Bank Bhangagar branch. Earlier, the said locker was operated jointly with her deceased husband, late Manjit Nath. It has been submitted therein that after demise of husband, the keys of the said locker is in the possession of the accused number 1, Kulendra Kumar Nath, who despite her repeated request have denied handing over the said key and her gold ornaments. As such, complainant prayed for issuance of search warrant for recovery of her gold ornament from the said locker. The accused person filed a written objection to the instant petition where it is stated that they do not know, this is important, Lordship, they do not know anything about the said locker. My landed for filing a Quashing petition in 482, and even they do not know what is contains in the locker unit. They do not have the key of this. Now they are denying that they have also do not have the key. With their note, do they have any access to the said locker? Even they do not have the access to the said locker, Lordship. They are filing the objection. And 3 times they file a petition before the landed trial court, Lordship, that they will hand over all the gold ornaments of the petitioner wife. The learned counsel for the complainant submitted that there is every likelihood for misappropriation of the said key of the locker number so-and-so and the gold ornament belonging to the complainant. Upon considering the material on record and the submission of the both sides, I see prima facie ground to retention the possible misappropriation of the Stridhan article of the complainant by the accused. As such, I deem it proper to issue general search warrant for searching the flat number so-and-so, issue search warrant to the OC Bhangagar PS, authorizing him to conduct the search of the flat accused at the above mentioned address and to recover the key of the joint locker number 70 of the ICICI Bank branch, Bhangagar branch, for possession of the article. The complainant is hereby directed to remain present during the search for the identification of the said key. Now, Lordship, each and everything is clear, Lordship, in this order passed by the landed trial court, Lordship, that they appellant accused himself admitted in written before the trial court that they do not know what is the contention of the locker and they do not have any assets. They do not know anything about that locker. And she is claiming that my ornaments are lying in the locker, Lordship. And that CR case is pending since 2022, Lordship. And there is no infirmity, illegality, any order passed by the landed trial court. And appellant Lordship has materially suppressed before this honorable court that they have given the consent that they will return all the street and article of the petitioner wife.
Where is that?
Lordship, the LCR is there, Lordship. That is on 16/6/2023. The petition which has been filed by the complainant, accused person, Lordship, a para 9, that the accused further states that accused do not have a dominion over the article, if any, lying in the said locker, as alleged by the complainant. Further, the said locker being jointly operated by the complainant with her deceased husband can be opened only observing the due process of law.
What is wrong, my lord?
Lordship, the petition, other two petitions are also in the LCR record, Lordship, which has been called by this honorable court, Lordship. Lordship, two judgment of the honorable apex court in this regard is very much important, Lordship. One is the Pratibha Rani versus Suraj Kumar, in which honorable apex court has held, Lordship, that the street and property is a property which belongs to the Lordship, only the woman, the wife, Lordship. That judgment is very much relevant, Lordship. In Pratibha Rani case, Lordship, the Honorable Apex Court, full bench judgment of the Honorable Apex Court. A Hindu married woman is the absolute owner of her street and property and can deal with it in any manner she likes, and even if it is placed in the custody of her husband or her in-laws, they would be deemed to be a trustee and bound to return the same, if any, when demanded by her, Lordship. Lordship, this judgment has been placed by my learned friend on behalf of the appellant.
What is your judgment?
Lordship, my judgment is Pratibha Rani Barche Suraj Kumar, 1985 to SCC, page 370, Lordship. Pratibha Rani Barche Suraj Kumar,
To SCC,
1985 to SCC, page 370, Lordship. In which Honorable Apex Court has held, Lordship, that the property of the wife is belongs to the only woman, Lordship. State and articles. No one other can claim, Lordship. Detailed judgment were passed by the Honorable Apex Court, Lordship. The head note is also, Lordship, enough in this case, Lordship. The ingredients of criminal breach of trust, dowry articles constituting the estate and property given by the parents of the Hindu woman.
370.
370. 1985 to SCC, page 370.
Which para? Now we have the judgment.
Okay.
Which para?
Lordship, head note is enough, Lordship. Lordship, ingredients of criminal breach of trust, dowry articles constituting estate and property. Even she is not claiming that part, dowry. She is only claiming her own ornaments. Property given by the parents of the Hindu woman to the husband and his close relative at the time of marriage. Dishonest misappropriation or conversion to own use those articles by the husband and others, whether by itself amount to criminal breach of trust or separate agreement for a specific entrustment of those articles essential to constitute such offense. Lordship, now this is important, second paragraph of that note. Section 482, petition under quashing complaint. Court's prima facie must be based only on the allegation made in the complaint, taking them to be correct. If clear allegation constituting the offense alleged are made, the court should be reluctant to interfere, Lordship. And Hindu law, Hindu women, this is the alternate remedy, Lordship, as my learned friend placed before this honorable court. Hindu woman Stridhan dowry article, nature of the wife ownership, whether absolute owner or joint owner with her husband, effect of section 27 of the Hindu Marriage Act, section 14 of the Hindu Succession Act. Entrustment of the Stridhan property to husband, whether husband amount to be partnership between husband and wife, Hindu Marriage Act, Hindu Succession Act, partnership, section 4, Lordship. Lordship, last paragraph of the head note, Lordship, section 4, criminal courts, jurisdiction in matrimonial offense, offense committed in capacity of husband or wife, if made punishable under IPC, would be liable to criminal prosecution. Existence of alternate civil remedy would not bar criminal jurisdiction. That is important, as my learned friend says that the succession case has been filed in the Tinsukia district. Even that was not maintainable in Tinsukia because the property belongs in Guwahati, in the district of Kamrup Metro, as per section 16 of the CPC, Lordship. Lordship, next page, 8 page 371, second paragraph, per Fazal Ali and Mukherjee says, a Hindu married woman is the absolute owner of her Stridhan property and can deal with it in any manner she likes. She may spend the whole of it or give it to her away at her own pleasure by gift or will.
Okay, we have seen that. Yes, Mr. Raghu.
She is the absolute owner of the Stridhan property, Lordship, of her own ornaments, of her own belongings.
Okay. Anything else?
Lordship, one judgment is, Lordship, very much relevant, Lordship, in which Honorable Apex Court has held, Lordship, under 482, Lordship. When this 482 can be invoked, Lordship. That Honorable Apex Court has held, Lordship, that in a routine manner they cannot file the case in routine manner. Lordship, head note is enough, Lordship. Quashing of criminal proceeding, they have approached this honorable court under 482. Inherent power of the High Court, nature of exercise of said power when justified. Inherent jurisdiction, thou wide, has to be exercised sparingly, carefully, and with caution. And only when such exercise is justified by the test specifically laid down in section 482, Lordship. Power to be exercised ex debito justitior to prevent the abuse process of court, but should not be exercised to stultify legitimate the prosecution. High Court should not assume the role of trial court and embark upon an inquiry as to the reliability of evidence and sustainability of accusation on a reasonable.
Mr. Agarwal, you have seen para 7 and 8, right?
Lordship. This judgment is, Lordship,
Okay.
my humble prayer before you, Honor. Lordship, they are very much relevant, Lordship. And by considering all the material facts and records, Lordship, the
Wherefore
petition
you are
maker-
saying that the accused persons have said that they are ready to.
Lordship, the petition they have filed, Lordship, that is on record in the Alsia record that is available, Lordship. I will flag mark it, Lordship.
LCA.
Even when the notice was issued, they made a reply to the notice also that they will hand over all the estates and properties. Or even after filing the case before the landed trial court, they have admitted that they will hand over all the properties. And now they are filing the petition after petition in the succession case they preferred in the district of Tinsukia, Lordship. By filing a succession case, which are not maintainable there. And now again, they have this petition has been filed in the 2023, Lordship. After 1.5 years after the search warrant was issued by the landed trial court, Lordship. And there is no infirmity, illegality in the order passed by the landed trial court, Lordship. She is not claiming any of the joint property of the accused person, Lordship. She is only claiming her ornaments.
There is, in the record, there is no such objection filed by.
Learned court below. So, Lordship, may I permit to my lord only clarify 2 points, my lord?
One thing, what we have seen.
My lord.
You have filed an objection, I believe.
Yes, my lord.
Somewhere it is, you have annexed also.
Yes, my lord. Lordship, that contained in page, my lord. Specifically, we have pleaded about that issue of my lord. That objection is, my lord, page 43.
Reply to the so-called.
Yes, 43. 43 and Lordship, the relevant part of the paragraph is in, my lord, page 14, paragraph 14 and 15, my lord. Page 43. As a case of joint property, my lord, the local cannot be dealt with in a manner of, my lord, as they like for, my lord. Their law is there, my lord, that has to be applied to.
But it's a joint account.
Exactly, my
If it is a joint account, what is the necessity?
Exactly, my lord. The joint account is there, my lord. Suppose take it for a moment that
If it is a joint account, because what we have seen, that 2 persons have come up from the side of the accused person.
Exactly, my lord. Kindly see that.
In one of the cases, you said that you are not aware of such accounts.
Exactly, my lord. See, my lord.
And secondly, when it is a joint account, definitely it will be either or survivor.
Exactly, my lord. That's right.
So if you are having the key, that's what is required.
Yes. My lord, question is that, my lord, the issue about key is a different term, my lord. For a moment, Lordship, can you take it for that? Let us presume that their students is lying there, my lord, in local, my lord. Taking that, my lord, for a moment. Now, for that purpose, my lord, in order to operate, my lord, Lordship, well aware that, my lord, succession certificate required before the bank, my lord. The bank once gets succession certificate in respect of the concerned legal heir, my lord, then they'd be allowed, my lord. Now, in that case, my lord, that article will come out, then issue will be decided that whether the students lying there or not, or the list which has been enclosed material or something else is there, my lord. Then the thing will be dealt with that way, my lord. But issue is that, my lord, this honorable, that learned court below passed to contradictory order. At first instance, my lord, it excluded that part of, my lord, that issue of, my lord, local and accounts. Subsequently, it has been issued that that key has to be, my lord, searched for that. Lordship, take it for that, my key is being handed over to her, my lord. Can it be possible, my lord? What purpose it would serve, my lord? Suppose it's a, my lord, property of that husband, my lord. There is nothing of Sridhan, my lord. And my lord, there is no whisper earlier that anything lying in the locker, my lord. The first petition which they moved, no. Divorce petition, no. Only first instance, my lord, when they raise this issue, lord, say, kindly look for a moment. I just want to only clarify one part, my lord. Page 52, my lord. Lord, say, kindly have a look at page 52 for a moment. Page 52, my lord. Order dated 16/6/2000.
Just
My lord.
Mr. Agarwal, do you have the petition 1144? Copy of the petition.
1144. Now, 1144, 2022. But this issue has been agitated first time, my lord.
We haven't application that you have filed 1144, but the objection filed by you is there.
Lordship.
Do you
I
have?
do, sir.
Heard Mr. Maria, counsel appearing for the petitioner. And Mr. S.K. Agarwal, learned counsel for the respondent. Petitioner. Pursuant to the order is 05-10-2023. By which the record of CR case number 3845C of April 2022 was called for. From the Court of Ghana Judicial Magistrate First Class. The first call for Judicial Magistrate First Class Kamruk Metro. Received the same. But it doesn't contain the applications. More particularly, the application number one 2023. Filed by the respondent inside CR case number 384562 and the reply filed by the complainant filed by the accused persons to the said petition number filed by the person on 0206-2023 in beauty of the Chief Judicial Magistrate Kamruk Metro County as well as the Judicial JMFs Kamruk Metro County. Will forward the rule scan copy of the petition number 1144 of the 2023. Alright. Complaint and respondent. Along with legal. Then it's as well as the objection filed by the court. List of 17th September.
No, interim order is there.
The interim order first
17th September. Deeply.
Oblige lords.
Mr. Algo, wait for a few minutes.
Much obliged.
Deeply obliged, lord.
Let me go, Lordship. Lordship, Alfier was called for, and I have checked the record, Alfier has come.
Mr. Vaishya,
My lord,
records have now come.
my lord,
Go through,
my lord.
tell us. Person to the order of business.
Lordship, I have prepared a note, Lordship may kindly pad on.
This is 0508/2024. Office note. No, उठा करो. Office note is 30/08/2024. Reflects that the person to the order of 5/8/2015 registry have received 11 records. Relating to dispute case number 2028/2015. Corresponding to PSC number 135/202. As well as the records of PSC case number 135/402. Mr. K. Bushel, an additional public prosecutor, is allowed to go to the relevant records. List on. Twelve. Give me what is there. Yes, next. Good building. What what?
For daily, I don't know why it keep. Until.
My lord, this is a POCSO related case, my lord. Hope we are not on going live, my lord. So, my lord, the present petitioner is behind the bar for 286 days till today, my lord. The victim has already been examined, and the informant, who is the victim's grandmother, she has also been examined. And as per the allegation, the victim had first approached the teacher and the principal, and she had narrated the incident to the teacher and the principal, and the class teacher and the principal has also been examined. So, my lord, all the vital witnesses have been examined in this case, my lord. My lord, the victim used to stay with her mother. Both the parents of the victim were separated since her childhood, and she continued to stay with her mother. And this time she came to stay with her father for around 5-6 days. And when it is alleged that the incident had occurred, now, my lord, our case is that, my lord, we have cross-examined all the witnesses. Our case, my lord, is that this is a pre-planned, my lord, pre-planned in a very pre-planned manner. The victim has been used by the family of the wife of the petitioner to falsely trap him in this case. And, my lord, in that line, my lord, we had examined the victim also, my lord. And we have in the cross-examination, it has very clearly come out how the victim has been tutored, my lord. We are only on that point during trial, my lord, that how the victim had been tutored. Kindly come to page 58, my lord. That is the part of the cross-examination of the victim, page 58. And from there, my lord, with lordship's permission, I would like to read from paragraph 19 to paragraph 26.
Lakhan, please hold.
My lord.
Anything you last to submit, we have seen the record.
My lord, we are saying that this victim have been tutored. Kindly come to page 58. We will show to this honorable court that what she has deposed and what the informant has deposed in these lines. Page 58, I am reading para 19, my lord. Lordship have got it. Since my childhood, my father did not take care of us. He did not discharge his duties as a father. He also did not take care of my mother and did not discharge his duties as a husband. When some visitors used to give us some money as token of love, like rupees 10, rupees 100, he used to take away the same. He also used to do the same thing with my sister. He used to take away her money. Now, my lord, this type of allegation, my lord, from her, my lord.
Anything else?
When my parental aunt used to give money to my father to buy clothes for us, he used to purchase clothes for himself and some clothes for us and thereafter he used to come and say that he had bought the clothes for us.
Mr. Khan, remember one thing, she is a kid. And above that, what kind of harassment she has undergone, only she can explain. Don't look into these things in that matter.
Then, my lord, para 21, my lord. My father used to collect the rent of the rented premises of my grandmother and did not give the same to my grandmother and kept it with himself. My father used to threaten my grandmother and collect the rent. Since my grandmother is old, as such, she
My lord, yes, of the case, yes, my, there is sufficient material against this person. My lord, the without completion of the my lord of work, my lord, for their own benefit, they have prepared my lord false bill, and they passed the all the final bills, my lord, without completion of the work.
Petitioner was serving as what?
There are two petitioners, my lord, the item number 37 and 38. One is my lord Saidur Rahman Lohkar and other is Baldev Singh.
What was their role?
My lord,
What was their role?
the role of the petitioners, my lord, they have preparing the bills, my lord.
They are
After
the
completion of the certificate, my lord.
They are the officials of that particular office.
My lord, yes. Here, my lord, actually there is a work, my lord, the work has been, my lord, under PMGSY, my lord, regarding road and bridge and many others, my lord, and some works of the government, my lord. That they have their duties, my lord, to after completion of work, their signature is necessary for the preparing of the final bill. But it has been found that, my lord, without having any completion of work, they have prepared a final bill and issued to the contractors, my lord. There consists of, my lord, 3.22 kilometers roads work and 5 numbers of culverts, 2 numbers of
Who are the
partitions.
petitioners?
Petitioners is, my lord, one is
Contractors or they are engineers or they are
yes,
supposed
yes.
to give, who are they?
Baldev Singha is the, my lord, AE, assistant engineer, and the Saidur Rahman Lobster is graduate engineer, my lord.
Okay. What is their role in this?
Their role is, my lord, the preparing of the bills, my lord, and pass the bills, my lord. And my lord, after preparing the bills, the payment was made to the contractors, my lord, without completion of the, my lord, the work which was allotted to them and their own benefits, my lord, they are doing all this, my lord, scamming.
My lord, with due permission, my lord, may I submit one thing, my lord? My lord, kindly see page number 20, my lordship. By page 20 of my petition, my lordship, Baldev Sinha, my lordship. My lordship, when this alleged incident happened, my lordship, and the bill was prepared, my lordship, he was even not there, my lordship. These are very important, my lordship. Page number 20, my lordship. He joined this service, my lordship, on 22nd of July 2022, my lordship. And my lordship, kindly see this alleged incident happened in the year 2022 in the March, my lordship. And the final bill was paid, my lordship, as per the FIR, my lordship, on 24th, 2022, my lordship. My lord, I have joined the service in the month of August, and incident happened in, my lord, in the month of April, my lordship. I was not even there, my lord.
Mr. Fukon,
my lord,
verify that aspect and tell us.
My lordship, the record is there, my lordship. Page 20, my lordship, my lord, my petition, my lordship. With due respect, my lordship, kindly see, my lord.
Here, my lord,
I'm sorry to trouble, my lord.
161 statement of the other independent witnesses, they are said that, my lord, these two persons are prepared the bills, my lord. Their own departments, my lord, the colleagues have been made in statement in the 161. These are the two persons.
The official verification when this person has joined.
My lord.
The official verification when this particular person has joined his service, Baldev Sinha. See, what happens? Earlier he was suspended.
My lord.
When he was suspended, we do not know. What the petitioner has done here has only shown that he has joined. This suspension order was revoked on 14th of August 2023. It shows him that hereafter he has joined. But when did he suspend it? It is not there. That petitioner did not mention.
Here, my lord, the one statement where I have found, my lord, where it is said that in view of the above, it is suggested that the government in PWRD take stern actions against the officials, namely Executive Engineer Mosim Ahmed Loskar, Sri Baldev Sinha, Assistant Engineer T. and Saidur Rahman Loskar, the then Assistant Engineer PWRD, who were involved in preparations and payment of bill without completing the work and sending false report to the higher authority in PWRD. It was also suggested by us the government may take stern actions by suspending from service the guilty of the official and blacklisting the contractor till completion of the departmental process.
My lord, may I submit, my lord?
Just a
Yes, my lord.
please come to page number 20.
Yes, my lord.
When you have been relieved,
My lord,
when you have been relieved,
with reference to Rule 140 of the
don't read
financial.
that. When you have been relieved, signs are there, signatures are there.
Yes, my lordship. 1st of August 2022, my lord.
Who was the relieving officer? Who joined in your place?
In my lordship, Birendra Das, my lord.
And when you have relieved, when you have handed over charge?
On the same day, my lordship. 1/8/2020.
So, till 1st of August 2022.
Yes, my lord.
You are the assistant executive in charge of the PWRD at Rathabari Territorial Road Subdivision. Is not it?
No, no, my lordship.
Only from 1st of August you are not there.
My lordship.
Prior to that you were there.
My lordship, I was there, my lordship. I was joined as an assistant executive engineer on that day, my lordship, on the 1st of August 2022.
Where?
Lordship, kindly the signature of the Birendra Das is also there, relieving officer, my lordship. And above, my lordship, Baldev Sinha's signature is also there, my lord.
Who is the officer? He is a relieved officer. That means you are released. And you handed over charge to Birendra Das. Where is the order of posting? Where is the order of posting?
My lordship, this is the relieving officer is
Where is
Birendra
the
Das.
order of posting? There has to be some order prior to that, right? Where is that order?
My lordship, the order is not there in the record, my lordship. But I have been in place of Birendra Das, my lordship. I have joined, my lordship.
You have joined in place of Birendra Das.
My
Read the second line.
Handed over and taken the charges of the assistant executive engineer Rathabadi as per notification dated so and so this for 22nd July.
Then after the signatures of Birendra Das on the left side, relieving officer, Baldev Sinha as a relieved officer. Then read the next line. I have occupied
the official residence allotted to me with effect from so and so.
So he has occupied from 1st of August. And who read the last line? Who vacated the official residence?
I have vacated the official residence allotted to from so and so. My lordship, there was no officials been allocated, my lord. Dates are vacant, my lordship.
That means who is the
My
relieving
lordship,
officer?
in that office, my lordship, there is no residence allotted, my
Basically,
lord.
that means you are the person concerned who was available.
It was only a format, my lordship.
Up to 1st of August.
Yes, my lord.
In the Rathabari Territorial Road Subdivision, you are the concerned executive engineer in charge. That what proves.
I'm sorry to trouble, my lordship. And kindly see the my lord page number 21, my lordship. For a second, my lordship. Page number 22nd, my lordship. It has been issued by Chief Engineer PWD, my lord. With reference to the above and pursuant commitment made by the contractor Alimuddin Tapadar by code affidavit to complete the work within November 2023, the contractor is allowed to execute the remaining work of above mentioned PMJ, my lordship. It is the chief engineer, my lordship, who has been allowed to work to complete his uncompleted work, my lordship, by order dated 26/10/2023, my lordship. I am a junior officer, my lordship. My duty is to only prepare the bill, my lordship. Passing of the bill, my lord, it is the senior officer. My lordship, I'm sorry to trouble, my lordship. Page number 23, my lordship, which is very important, my lordship. 22 is the connective page, my lordship. This is the inquiry officer report, my lordship. Submission of additional information on inquiry report dated 2/5/2023 in connection with the alleged irregularities in execution works of PMGSI package number AS13261, my lordship. Annexure 5, page number 22, dated 16/6/2023, my lordship. The next page, my lordship, which is very important, my lordship, page number 23, my lordship. What inquiry officer says, my lordship. amount of money required to complete the balance work of PMGSI package number AS 13251. Construction of Anipur NEC Road to Harinagar, Purbo Baruwala under PWD, Patarkandi and Rathabari Territorial Division, my lordship. The amount is required 43,38,702, my lordship, as per the report of the inquiry officer, my lordship. The next one is, my lord, more important, my lordship. The detailed status of fund available with the department, package number is the same, my lordship. The last column, my lordship, total money remained, my lordship, retained is 56,62,390, my lordship. As per the FIR, my lordship, dated 8/2/2024, there was allegation of irregularities, number one. Number two, the allegation of loss of amount 57 lakh, my lord. As per the inquiry report, my lord, is clearly saying the amount retained is 56 lakhs, my lordship. So, my lordship, there is no loss of money and there is no misuse of fund, my lordship. Only irregularities, my lord.
Do one. Go to the records. Tell us on Tuesday.
My lord.
My lordship.
Tell us on Tuesday.
My lord.
Right.
My lord, here from the record is clearly, my lord, revealed by the each and every statement of the 161 of the, my lord, the independent witness. They said, my lord, these two persons, sir, prepared the bills and passed this as their own signatures, my lord, and it released the bill amount, my lord. My lord, if they are not present at that point of time, my lord, the.
I have joined the investigation, my lordship, already and reported my statement, my lordship.
When?
Yes, my lordship. Kindly see page number 24, my lordship. Kindly see, my lordship. I'm sorry to trouble, my lordship. 24, there was a notice, my lordship, by the Deputy Secretary Abhijit Chaudhary, my lordship. And accordingly, my lordship, on 10/7/2024 at 10 AM, my lord, I have joined the investigation, my lordship. I have recorded my statement, my lordship. My specific signature has been taken, my lordship. On 10/7/2024, my lordship. My lordship, since the case is, my lordship, based on the documents, my lordship, which are already been seized, my lordship. So my humble submission before your lordship, my lordship, custodial detention is not required, my lordship, in this case, my lordship. All the documents are seized, my lordship. My specific signature has been taken, my lordship. So, my lordship, till next date, my lordship, no courtship action, my lordship. This is my humble prayer, my lordship. Since I am a government employee, my lordship, I have no way of absconding from the investigation, my lordship.
Public money.
My lord, but I am no way. As per the inquiry officer report, money is there, my lord.
This is an economic offense, my lord.
You have the documents with you.
My lord, yes.
My lord, I would like to place on Supreme Court judgment, my lordship, with due permission.
Please come to page number 17 on 7.
78 of my lord, the petition.
17.
17. तुम्हारे पास बंदे चाहिए ने बंदे चाहिए नहीं पास
बंदे चाहिए
page 17
17 first petition.
It's not, my lord, it's illegible.
Fire, my lord.
My lord.
2, 3 and 4.
Yes, as per the OMMAS, my lord. The work was shown and completed a physical on 26/5/2001. However, on scrutiny of the respective file, the work shown is completed physically on 24/3/2022. The final bill of the work amounting rupees so and so was paid to the contractor as on contractor on 24/2022. The first installment of SD memory was paid to the contractor on 9/6/2022. On visit to the work site along with the so-and-so and representative of the contractor on 14/11/22, it was found that the approach work of both the bridges were incomplete, not even executed to the EW level. Approximate length of the incomplete bridge approach work are approx 800 mm. During inquiry, it was found that the following government officer had committed irregularities in the implementation of the government scheme PMGSY package number so-and-so, tender value of rupees so-and-so, as the contractor had completed all other works, but the bridge approach works on 2 numbers of bridge were not done at site, as the bridge approach work on second number of bridge were not done, completed payment regarding the same should not have been made to the contractor, but the payment of the event bridge approach work of the second number of bridge were made by erring government officials giving false report to the higher authority and thus cause loss of government funds amounting of rupees 57 lakh approximately. The name of the erring government official is Satin Satna.
But the inquiry officer report, my lord, kindly reveals that the money is retained, my lordship. It is not lost, my lordship. And it is admittedly in the FIR, it is said irregularities, my lord. This is not misuse, my lord. Money is there, only misuse, my lord. Irregularities, my lord. For irregularities, my lord, PC Act cannot be come out, my lord.
Here,
My lord, with due respect, my
report
lord.
it clearly says, my lord, there are the fund amounting rupees 62 lakhs 97,000 by the loss of the government, my lord.
But money is retained, my lordship, as per the inquiry officer report, my lordship. My lord.
Due to their false report, the higher authority thus causing a loss of government amount, my lord, 62 lakhs 97,000.
Since the petitioner is making some claim, go through it, make your submission on Tuesday.
My lord.
You go through. List on Tuesday.
My lord, till then, no courtesy action, my lordship.
That
I'm a
cannot-
government servant, my lordship.
That cannot be. But 39 is the same thing?
My lord, yes.
37, 38.
37, 38, my lord.
37 and 38.
Together and Tuesday.
My lord.
Yes.
Well, the POCSO matter, lordship, this is service is awaited.
Any report from the Mr. Bush,
My lord, report not received, my lord. Yes,
Get the information from Agomani police station
my lord,
at the earliest.
my lord,
Today is 5th. We are having it on 13th.
my lord.
List on 13th.
All right.
Yes, yeah.
Yes.
But in this matter, CD not received, my lord.
From Dispur,
My lord.
when it was called for? When it was called for? 38th of August, okay. 12th August,
12th,
12th of September, sorry.
my lord.
What is relating case here? এই দুটা ম্যাটার আপডেট করছিলেন খালি দুটা ওদের চলছে তো টু ম্যাটার্স খালি একটু
Item number
two
45.
matters today morning upgraded.
Lordship,
Those two matters will be taken up tomorrow at 2 o'clock.
45 was one of them. We made a mention.
43, 44 and 45. It's tomorrow.
Lordship, one maintenance matter was there in as well criminal revision matter. It was listed in several times also last occasions also.
Which item?
But it may be
Item
taken up in
48.
the next week. 48 item. 48. My colleague is here also.
No, other matters Kundina fixed course to maintenance matter.
In the next week, it may
Yes,
be,
Lord.
No, it has been fixed.
in the next week, it may be, because they have stopped the, even the.
No.
I have the certified copy also here. They have stopped the interim maintenance amount also here.
Which item?
I have got the certified
48
copy also.
48.
Okay.
48 item. Item number
48 along with item number 49. 49 to help now. All 9, 10, 11, along with 9, 10 number to first. Criminal petition 1295202 on 12.
On 12.
Okay.
Lordship, deeply obliged. Interim may continue, Lord.
It is there up to.
Lordship, deeply obliged.